we'll start. Say hi. No? Should I say no? Say hi. And then I'm gonna go outside and you said just gotta relate people and
We're good.
Hi, good morning, everyone. Thank you for being here on this very sunny day. I know that it's a challenge, but I think it should be very worth it. So this is the tentative schedule. Give or take 10 minutes for coffee breaks. Marie O'Leary, as you know, you have a biography. You should also have a full case and something like this, which is called an annex. So if you do not have all 3 documents, let one of us know, but you should. Ask Isabel or I any questions. You've been dealing with Isabel Mayer-Landry, not Dusterhoff, which is a cause of very big confusion for many people. And I'm Dana Lee, so we're here to help you, and I hope you enjoy the day. Thank you.
Thank you very much. I sort of worked out the Isabel, calling her Isabel M in emails, and Isabel D is in the same email, and it makes me think of when you were 5 years old and your friends all had the one initial last name because they had same names. Thank you very, very much for coming today because I think this is a very interesting topic. I was trying to think of if I had ever even seen a full day on witness proofing alone. It's typically not done as a standalone training. It's usually a component of other things because it does factor in to the whole process. So you'll see if you're doing direct and cross, people may be discussing how witness proofing affects it. You may have it coming up in other sort of oral advocacy or trial advocacy courses. But on its own, it's a bit unique. So I think there's a lot to go over here simply because we have different courts, different systems, and different backgrounds that contribute to a very subjective nature of this topic. So I think it's something where when we get into it, we'll go through some of what's happening in the courts. You'll see at the beginning, we're going to start with the who, what, when, where, and why, because I was thinking that what do you think about with witness proofing? Who's involved? What is it? What are you doing? Where are you doing it? When are you doing it? That's a very important question with witness proofing. And after the coffee break, we will get to, and how? How do we do this? In the afternoon, we're going to go through a couple exercises that would be related to witness proofing. So, because you don't want to listen to me talk all day long, especially with the sun beaming out at us. We have a smaller group. I blame the sun on that one too, but maybe that will facilitate going a little bit faster anyway, so if we speed up, I don't think anyone's going to complain. We'll do all of the content in as much time as it takes, but we won't hold you over, that's for sure. As far as this goes, it's good to have a background of who is here and what we're doing. I know a lot of you have experience in tribunals in the ICTY here, at the ICC, STL, so it's good to kind of know, and with a small group, maybe I can get an idea of who could define, and I'm not going to ask you to, but who in the room, just by show of hands, would be able to define what witness proofing is? You're confident. Okay, and what about witness preparation? Okay. And witness familiarization? Okay, good. This is good. We're going to go through all of them. Who in the room, I just wanted to know, who has proofed a witness or been involved in a familiarization process with a witness? I have one person. Okay, good. And who has been on the receiving end of a proofing note? One. Okay, so we have a lot of experience in the rooms when we have trainings like this, so I think it's very good that then we can share, because you may have different experiences or you may have different experiences. So if you have any questions or things to add, feel free, anyone, throughout as we go. One more last note, I speak very fast, I know this. I don't have an interpretation booth here to tell me to slow down. I don't have my mother to tell me to slow down. None of them are in the room, so I'm relying on you. So if it gets a little wild, out of hand, especially reading things, just give me the universal sign for slow down as we go. Starting off, let's start then with the what and the why. Why are we doing this? What is it, actually? If you're looking to the ICTY manual or the ADC ICTY manual, you get a definition. It says that there's no set definition, but then it tries to provide one. Essentially, I'm just going to try to pull things on the screen here, and I was saying I'm a bit antiquated because I'm using Word as PowerPoint. Just go with it. Witness proofing, it generally refers to a meeting held between the parties to the proceedings. It's done shortly before the witness is to testify in court, and it's for the purposes of preparing and familiarizing the witness with courtroom procedures and at the ICTY, because it's from those manuals, for reviewing the witness's prior statements. That has been a definition that has been largely adopted then by the courts. This is the same definition that's been discussed at the ICC, for example, when you get to the Kenya cases. This is generally the overarching definition of what witness proofing might be. This is defined here. Now, when we get to witness preparation, it's actually pretty much the same thing. Witness preparation is a different term that's used. At the ICC, for example, they're using the term witness preparation. They're not using the term witness proofing. But in essence, it is the same thing. If you're hearing preparation, if you're hearing proofing, these are the same things. So you can put them in the same box. A little bit different is witness familiarization. That's in a different box. They are linked. Sometimes if you look at sort of a Venn diagram, there's over a middle bit that might be the same, but they're two different things. Witness familiarization is typically when you have the victims and witnesses unit or section of the court involved in simply telling the witness what's going to happen. It's a more general nature. It's not preparing their testimony, so to speak, as to the specific topics, but it's more going to, what is this court? Who is sitting over there? What is the role? What is expected of the witness? Definitely neutral sort of an activity to prepare them so that they have less anxiety. Because you can imagine coming in as a witness, and anyone who's worked here in victims and witnesses units or with victims and witnesses, you know very well that this is a new world. It's a new world for us coming in here even when we start. So they need some sort of instruction as to, this is what the legal process is here. Here's why you're here. This is what the courtroom is. So the first time they're seeing it is not when they walk in that first day and they're nervous because they don't know what's going to happen. Instead, they're given a tour of this very simply, very neutrally. This is where the judges sit. They're going to be in robes. There will be 3 of them. This is where the defense will sit. Their role is, and so on and so on. It's meant to be a very neutral activity that is taken on by the registry of the court. That's not to say that the parties don't engage in witness familiarization as well. Sometimes there's some overlap. And this is what we're seeing now as well at the ICC in the protocols that have gone out. You're starting with a witness familiarization protocol that was in existence, and it's being developed into familiarization plus preparation, and where are the lines and who's performing which role, so that there's not overlap, duplication in that sense. I had a little clip here. I forget that there's no YouTube at the ICTY. I'm over at the ICC where we have YouTube, and I entirely forgot when I asked if there's Wi-Fi. But basically, if you type in witness familiarization, this is a very simple link that shows, I think it's the UK government, who's done something. You're a witness. Now what? And it goes through steps, and it's a cartoon, actually. And it's this sort of a thing that is actually a witness familiarization activity. It's something where it's meant to be very simple, so everyone of all capacities, ages, backgrounds can grasp what it is that's going to happen in that courtroom. And it is something that's done largely across the board in many jurisdictions. The textual basis, so what are we doing and why are we doing it? You won't find it in the texts. You're not going to find it in the ICC texts. You're not going to find it in the ICTY text. You're not going to find it in ICTR. You're not going to find this in the textual elements, so to speak. There are some caveats. At the STL, you'll find it in the Code of Conduct, actually, which we'll discuss a little bit later. But you won't find it necessarily in any of these texts that witness proofing is allowed. And that's where we have this system that has sort of evolved and developed. And that's why we're talking about it today, because there have been many bad practices and good practices that have evolved throughout, that have got to a point where we've sort of reached a culmination of creating protocols, actually, over at the ICC. And again, that's something we're going to discuss in the how. Specifically, if you look to the jurisprudence, they have told us that the texts are silent. This is the Milutinovich, there was an Oidnich decision in 2006, and they have said specifically that the rules of procedure and evidence are silent on the issue of witness proofing. It's simply not in there. It's simply something where you have to go back and look at how this practice has developed in the jurisprudence. And so to do that, actually looking at one of the earliest, This is a case from 2001, and this is one of the first times that you'll see a discussion on the record about witness proofing. Judge May is actually from the UK. You have also Judge Robinson, who's from Jamaica, who are both involved in the process here in this discussion. You'll see here they're talking about the reason, the why, as to why we're doing this. Basically, statements were taken a long time ago. Right up there. But statements were taken a long time ago. And that's the why, as to why this has started to develop here. Statements in these cases have been taken perhaps 10 years ago. And then when you bring the witness to trial, if there's no interaction with them beforehand, they might have remembered new things. They might have changed their mind. Things evolve, things change, people forget things. And you don't want somebody on the stand all of a sudden trying to work that out in their own mind when they have the record going and everyone watching, and time is of the essence because courtroom time is not cheap. So there was some value in actually dealing with the witnesses when they first came back and saying, this was your statement. Is this all accurate and true? And witness might say, actually no, they got that wrong. Another element to this is the languages that go on and the way statements are taken in these courts. Typically you're working with translators when you're taking statements in the field. There's a lot of different language pairings going on, practices as far as perhaps maybe the statement is taken and done in a summary format, in which case then it's translated or read back with an interpreter. It leaves a lot of room for mistake to be made, and it's not the fault of anybody necessarily who's involved in the process. It's simply that whenever you're trying to work between two languages, you know that there is room for error. And this is simply, you all work in international environments, and you know that this simply happens in the most mundane of conversations. So when you're relying on specific words in cases, specific facts, specific dates, things can get wrong. A number can easily be the wrong date, the wrong time, and when you have that happen, it might mean everything to the case, but perhaps the witness didn't know at that time when they were reviewing. They saw it, they didn't see it, but they didn't know that that was a crucial point and didn't think to correct it. Maybe they didn't even know they could correct it. It's something where you have to take all of that into account as to how these statements and the process of investigation goes, as to why witness proofing or preparation becomes necessary later on. It's because of that time lapse, typically. Timing is very critical in all of this. You'll see the latter half of this actually is this section at the bottom here. You're talking again, here's timing, but that's a different issue that comes up with witness proofing. And that's where, because you had this interview 10 years ago, and now the witness is here, and it's convenient because they're in The Hague, so it's easier to talk to them again. You don't have to make a separate trip closer to that date. But their testimony starts tomorrow. And so they're having this discussion, and any changes come up, you have to notice to the other party. And if those changes are significant, what is the other party supposed to do with it when they've been preparing for months, maybe years, on the basis that this is the testimony of this witness? So then you're reaching points that are too close. So we've got the too far away, sometimes with statement taking, but too close as far as the proofing process. Yeah.
No question. So, in order to prevent confusion, when the statements are taken, is there any impetus to then give the actual witness a copy of the summary?
This statement in the field?
Yeah, kind of closer to the time when they give the statements, and then they kind of have it, and I don't know. Just
Yeah,
is that a practice or not really?
There are different practices. It depends on the court and depends on the investigation team and what their guidelines are as far as how they're going to be treating this. They definitely go over the entire thing with it very clearly because that witness has to sign off on it. Right. And of course, then they can have access to that information because they're a part of this. However, it's something where then they might not have any recollection of it later on. They might have thought of new things. This isn't something where people are thinking about their testimony constantly. They've given their account, and then they're done with it. Their life moves on. 10 years later, when they're called as a witness, oh yeah, what did I say? I don't even remember, because they're also not understanding the context. When we talk about purposes, it's meant to focus it as well. Because a witness, especially if you're looking to war crimes, crimes against humanity, has a breadth of knowledge of a multiple array of topics. It might have been events happening on this day. It might have been events happening on this day. what is the exact case and what do they need. So it's also focusing it into, this case is about this, so what exactly do you need? This second part here I left in here, it's actually within the same transcript, but here's where we're talking about the problems that come up then for the other side, as far as these have been done relatively late within a 24-hour period, and the summaries are coming in. These summaries are where you're getting into those proofing notes, actually. And that's the disclosure that's being given to the other side. Where did we get the idea of witness proofing from? We didn't just come up with it at the ICTY or at the ICTR or SCSL. No one just dreamt this up one day. This is something that's actually routinely practiced in many domestic jurisdictions. I don't know, does anyone practice in a domestic jurisdiction who utilizes proofing or preparation? One? Oh, sorry, where are you from?
I'm from Bulgaria, but I work in Bulgaria and Spain too, so
Okay.
I'm in two different countries.
Okay, and it's allowed in both countries, or? Okay. My understanding is there's some commentators or people who will say that there's a distinction between civil law and common law as far as this divide here. Yeah.
For example, in Lebanon, as lawyers and counsel, we are not allowed to be in contact with witness.
Exactly. This is the same thing you'll find in at the ECCC, the Cambodian courts, their code of conduct. The lawyers are not allowed to then approach the witnesses themselves. Therefore, you would have a real problem if they're attempting to prove or prepare the witnesses. That simply is not going to be allowed under their codes of conduct. However, on the flip side, I happen to be from the United States. It's a large field of proofing that you can do. We'll look at some of this and where it's a gray area and where the lines are here. But there's a lot that you can do, and actually in the United States, you can be held responsible under a code of conduct if you didn't properly prepare your witnesses. If you didn't tell them this is what's going to happen and get them ready for court, you might now be in your own violation. You might be a violation or misconduct actually as your duty as an attorney to prepare these witnesses for the trial and to run a fair, open proceeding. So you have the flip side of it there, as far as that's quite broad. Many of these decisions actually refer to the UK and how the UK prohibits it, and barristers cannot be speaking to the actual witnesses. But sometimes what it actually leaves out, and if you read Judge Ivo Azuce's partially dissenting opinion in the Kenya case, he goes into it quite detailed manner, which we'll discuss his partially dissenting a couple times here because it's very elaborate. He's discussing the differences in the system there, in that the UK has a system where they have solicitors and barristers. And solicitors are allowed to approach the witnesses and familiarize them or do some level of proofing and preparation. It's simply the barristers who will not be performing that function necessarily. And there's also been a trend that has gone to allowing a bit more preparation or proofing. So it's not an end-all be-all. You can't look at systems and take them in the same context as your own system. In the US, we don't have a barrister-solicitor system. Therefore, it is the lawyer who's doing both the solicitor and barrister work. Therefore, they're the ones who would be doing any preparation, proofing, approaching the witness as far as the party does. In the U.S., I just find fun terms. It's sometimes called horse shedding or wood shedding. This is just fun terms if you ever want. It's basically because that's where this last-minute proofing was supposed to have been taking place over in the horse shed and the wood shed, these last-minute preparations with the witness. So if you hear those terms, that's what that might mean, actually, simply based on location and the colloquialism. As far as the broadness of the U.S.'s parameters, I actually marked down, I don't think I put it on my little screen here, oh, there's that. Well, that's, all right. A less than perfect system here technologically, from me. But I wanted to tell you about Section 116 of the Restatement of Law Governing Lawyers. And this actually comes up again, Judge Ivo Azuce is referring to this. But this is something that you will hear, sorry, it's not up here, just have to read it to you. But the Restatement of Law in the U.S. are where they are trying to consolidate or synthesize the common law practices within the jurisdiction. And so they have some restatements of law that are put out there. And Section 116 actually says the following. In preparing a witness to testify, a lawyer may invite the witness to provide truthful testimony favorable to the lawyer's client. Preparation consists with rule of this section may include the following. It may include discussing the role of the witness and effective courtroom demeanor. It may include discussing the witness's recollection and probable testimony. It may include revealing to the witness other testimony or evidence that will be presented and asking the witness to reconsider the witness's recollection or recounting of events in that light. We're getting pretty broad here. Personal opinion, but I think this is getting quite expansive. And close to those lines of where we're getting into where we'll talk about witness coaching. Discussing the applicability of the law to the events in issue. Reviewing the factual context into which the witness's observations or opinions will fit. Reviewing documents or other physical evidence. Discussing probable lines of cross-examination and how they should prepare for that. And finally, it states, witness preparation may include rehearsal of testimony. A lawyer may suggest a choice of words that might be employed to make the witness's meaning clear. However, a lawyer may not assist the witness to testify falsely to a material fact. So you can see the difference if we have, say, for example, Lebanon or we have Cambodia where you can't even approach them. To here, we're talking about rehearsal of testimony. We're talking about the context and suggesting how that might fit in. It's getting very, very close to a coaching line, if you ask me. I find this to be a very, very broad idea of what witness proofing might be. But you can see how much area is in between this as far as you're over here not approaching. You're approaching them to tell them this is what the courtroom is. You're approaching them to tell them, just simply ask, are your statements still correct? And over here you're getting to a, here's how it fits in and here's what we're going to do and let me tell you the questions actually. Because that's actually allowed. They can give the questions, here's the questions I'm going to ask you. The line then that they're discussing over here is, you can't tell them what the answer is. You can't suggest the answer. You can tell them what you're going to ask, but you can't tell them how to answer it. And that's meant to be where the line is over here, but it's still quite broad in my personal opinion. That is cited, though, again, in that partially dissenting opinion as far as looking at other jurisdictions. He's referring to this and discussing how that's that broad idea that's out there, too, and that's where we're getting this from. This is where this comes from. Are some jurisdictions go that far? But again, it brings us to the why. Why are we doing this? There are arguments for and against. I'm sure there are some in this room on either side as far as whether this should be done, whether not, because there are dangers into getting into that level of witness coaching. The why has been broken down by one treatise, at least, as to help the witness tell the truth. To make sure the witness includes all the relevant facts, to eliminate irrelevant facts, to organize the facts, make a sequence of them, to permit the attorney to compare the witness's story with the client's story, to introduce them to the legal process, to give them self-confidence, and this is where you're getting into some ideas, too, of setting the witness at ease. And while this is done by the Victims and Witnesses section here at the court, which is not something you would necessarily, in the U.S., you're not going to have the Victims and Witnesses section or unit to be doing those practices for you. That's why the attorney's also doing that. Here, we have the benefit of those sections and those units who are able to set the witness at ease and to tell them about the process and do some of that general work. And that's where the line is now being drawn. How much of that goes to that section and how much of it goes to the actual party who's calling them? Who's doing what? So the witness is not inundated with potentially different information too. But it comes down to, you want to set the witness at ease, to fight that anxiety, to make sure that they are going to not only be able to deliver testimony that is open, that is honest, and that is not going to be all over here, but focused on the events that we're discussing, but also to do it in a manner where they are not freaked out. I've never testified. I don't know if anyone in this room has testified in any court. Have you ever testified? You've testified in a court. But you're an expert. I mean, was it a comfortable experience?
No. I was a lawyer when I testified, and I knew what happened and what I have to expect, but I was terrified. I didn't know why.
Yeah.
It was terrible.
Legal processes, even if you're not the subject of anything. I have been a part of interviews. I found those also a bit, there's a seriousness, a gravity of these proceedings that already imposes a level of nervousness on people. You don't want to get these things wrong. You want to make sure you're doing whatever it is that's going to assist the court. So you can imagine if you also are not a part of this, you're a lawyer and you're nervous.
Yeah.
You understand legal proceedings and you're feeling at unease. What does that mean then for someone who is not involved in any judicial process? What does it mean for someone who is not necessarily exposed to as many legal practices as we all are in this room? What if they've been exposed to no legal practices? What if they're just from some small village and really don't have any idea of what is actually wanted here? There's a great need to make sure that everyone is set at ease, and that's why we have the victims and witnesses sections in units, but it's also incumbent upon the party calling to make sure that this happens. And that's where proofing and preparation comes in, to make sure that they understand why they're there with regard to the testimony. That's why it's being allowed. There's the who and the where also. Who's doing this and where are we doing this? We already discussed the why and the what. There's also the when, but we'll get to that in a second. But all of the international tribunals and courts are allowing familiarization, and that's being done, as we said, by these victims, witness units, and sections. All of them are doing that to some degree because these are unique systems, and they want to make sure that the witnesses are comfortable, as we were just talking about. As far as proofing and preparation, who is doing it? A lot of people will say the ICC is not doing. You don't have proofing. I hear this a lot. But the ICC, they prohibited proofing. They did a while ago. But things have changed. So we have to talk a little bit about the evolution of how this has got into a state of development to a point where the ICC is now actually going towards allowing witness proofing. They do allow witness proofing in at least 2 cases and are looking to add it in other cases. The first time that it actually comes to, I think, great light here at the ICTY is in the Limai case. You had a lot of litigation that occurred about the witness proofing practices that went on. There were fears of witness coaching as they're looking at some sort of avenues to take to make sure that that line was respected. I know I have this one up here. Oh, what is that? In the Limai, this is from a decision in Limai where they said the practice of proofing witnesses, both the prosecution and the defense, has been in place and accepted since the inception of this tribunal. So even though it hasn't been discussed at length in any of the texts, it hasn't been discussed in a lot of filings, it's acknowledged here that since day one, this has been going on. And it's certainly not unique to the Limai chamber. They also acknowledge that this is coming from these adversarial systems that we were just discussing. It has a lot of advantages, and then they go to talk about some of the disadvantages. But essentially, in Limai, they say, yes, we're going to be having this process going on. It's going on, and it's allowed here, and that's the way it's going to be done. About the same time, though, that this decision comes down is when we have the Lubanga prohibition on it. In the Lubanga case, the chamber said, no, we're not going to do this. They start off largely by saying the ICC statute has, through important advances, created a procedural framework which differs markedly from ad hoc tribunals. And this is where the ICC is separating a little bit and saying, we're different. They go on to explain why they're different or why they perceive their practice to be different here. The chamber says that here the prosecutor has a duty to also highlight exculpatory evidence, and you didn't have that before in the ad hoc tribunals. They have a couple of different, they have to rely more on domestic law at the ICC because it's part of the text, is choice of law that's going on in the text of the Rome Statute. They talk about a couple of different things that actually are going on that then separate them. So then they come to the ultimate conclusion that with regard to any discussion on topics to be dealt with in court or in exhibits which may be shown, the chamber is not convinced that either greater efficiency or establishment of the truth will be achieved by these measures. Rather, it's the opinion of the chamber that this could lead to a distortion of the truth, and it may come dangerously close to constituting a rehearsal of in-court testimony. The Lubanga chamber decided, we're not going to do this. We're not going to have this proofing preparation. They still have the familiarization that goes on to make sure that the witnesses are still being greeted and explained as to what is going to happen, but they're not going to allow party contact with the witnesses. They put a very firm line under it saying they note the prosecution, the undertaking of familiarization. They'll take any steps to limit pretrial rehearsal during a proofing session. They said it's not practically achievable. They were worried simply that even though everyone said, look, we're not going to coach, we're going to abide by all limits, it's not practically achievable, is what the decision said. This isn't going to be possible. We have no way of controlling this. We don't know what's going to happen. And they say, no. They also were worried and had a concern about how this will diminish the spontaneity of the witness's testimony. They're worried that when it's rehearsed, then people are coming in and basically you have what might be simply an oral reading of a statement. It's a rehearsed, memorized, rote testimony, and that's what they were trying to avoid. Because in the search for the truth, the judges were saying, we need to have the witness fresh, untrained, and ready to answer questions that come to them so they have a spontaneity in their answers. They say it can be of paramount importance to the court's ability to find the truth. So it was the spontaneity that they were looking for, actually, as far as having the witnesses testify fresh, as it were, without any sort of proofing. There were some concerns filed about whether this will re-victimize the victims who are also witnesses, if they're on the stand and things are coming at them quite unexpectedly. But they said they're not convinced, actually, that this would be the case. The chamber said, we can manage the proceedings, we'll make sure they're not re-victimized, and we'll do this in a controlled manner, so it will be okay. What you have after that Lubanga decision then is, of course, in the ad hocs, you have, for example, the defense team of Oidnich in the Milutinovic et al. Case filed something saying, hey, the Lubanga case said we're not going to have proofing anymore, and here's why. We shouldn't have proofing anymore either here. And this is partially because the practice had been growing to a level where you're getting those late notes of proofing, and it's making it hard to react and develop the case as it goes. The decision actually was no. It's actually quite an interesting decision if you read it. It takes place on 12 December 2006 in the case of Milutinovic et al. They basically go through and they list how they're different from the ICC then, whereas the ICC had distinguished itself from the ad hocs. Here the ICTY is distinguishing itself back again and saying this is why we're not the same. There's at least one very interesting point where they're also talking about the timing of it, because in this paragraph 15 they're talking about a third consideration here of well, you're talking about one witness in Lubanga that you're dealing with for the confirmation of charges at this stage. We're talking about hundreds of witnesses that we're dealing with all the time, simply because the tribunal was at a different state. And they said, so we have different considerations, simply in time, in that the ICC was still quite young at that point. They still were very early in Lubanga. They hadn't gotten rolling to multiple cases at the same time and trial proceedings with multiple witnesses. It was very limited. So, in fact, they say, in contrast, the chamber here must consider the practice in the context of numerous witnesses who will have or will testify in an actual trial. So it's worth reading, I think, some of these where they talk about how then they're different from the ICC, and this is why it has to happen at the ad hocs. And the ICTR has similar jurisprudence in this vein. They don't find that it will cause any undue prejudice to the accused to continue with this process. But they simply say that because the crimes charged occurred many years ago, and here's where we're talking about that timing, and in many cases the witness interviews took place a long time ago, it assists in A, providing a detailed review of relevant and irrelevant facts in light of the precise charges. It aids in the process of human recollection, and it enables a more accurate, complete, orderly, and efficient presentation of evidence in a witness at the trial. It also identifies and puts the defense on notice, so there's no undue surprise. So this is actually, they're saying, it's a benefit to the defense. There won't be any surprise in the trial. You'll see there'll be no surprise because you're going to get the proofing note the night before that's going to tell you what the surprises are. So it's something where they're saying that's actually a benefit. But they're also talking here then about the late proofing of witnesses. And this is where Judge Bonamy, who has pronounced on this in court many times, if you read in the manual, there's some snippets actually here in the witness proofing section. He is very, very concerned about the timing and the late proofing. And it's here and it's in italics, emphasis in original, It is the late proofing of witnesses rather than the proofing in and of itself that may be leading to disclosure difficulties, is what they're saying. So here's where we're talking again, the timing is quite difficult. They are saying actually that ideally proofing should be completed during the pretrial stage of the case. So that's much earlier than it's actually happening. Because in practice, anyone who's worked here, you know what's happening when they come here, and that's a day or two before. That's not at the pretrial phase. Pretrial phase, there's a lot going on, and the parties don't necessarily, I think, have time to be going back and re-interviewing witnesses. This is discussed in many, many filings. But ideally, that's when this would happen, according to them. That way, then you could sort it out closer to the time that it starts. So it didn't quite work. They did try to take from Lubanga and then quash it here. Didn't work. So they continued on, and it became fairly standardized practice in the ad hocs. It still goes on today. You'll have witness proofing that goes on here. It's proofing here, preparation of the ICC. But you'll have this that continues. You have also notable difficulties that come up along the way. If you look to the Hardini trial, there's a lot of discussion about whether these should be audio recorded or video recorded. And this is where you're starting to talk about those practices. And this is important on the timeline because this is about in 2009, I think you have some decisions here, 11 even about this. But throughout, in this time period is where we're at now, 2009, 2010, 2011, where they're saying maybe the answer to this is we video record these or we audio record these. And that way if there's any improper interference, perhaps we can have them disclosed. And they're looking at this as a solution that you don't get rid of the practice in total, but instead, let's try to regulate it in some way. And that's where they went with that. However, the Hardini, there's a decision actually, that the one I was just referring to, where they actually say, no, we're not convinced that we need to continue with the audio recording of this. It's fine, we don't actually need that. But you'll have the proofing notes, and that's going to help you out. Back to those proofing notes. They're a very vital component, and that's when you're looking at proofing. You're not just looking at it as I'm the one doing the proofing. What about the other party? What if I'm the one receiving? There are two different components in proofing. Are you the one proofing the witness? There are a lot of things to consider there. Or are you the one getting the note? A lot of things to consider there. So both sides you have to consider. It's not simply just the act of sitting down with a witness. In that Limai decision previously, where they were talking about they didn't want any surprises in the courtroom, I think it's quite interesting. I don't know if you've ever seen this. Maybe you have. I'm going to show you a quick little video from a movie. It'll be only about 2 minutes, but it's basically let's say a dramatic recapitulation of what happened with one of the first Lubanga witnesses. So this may be familiar to you, maybe not, but
Criminal court is now in session.
Okay, great.
Please, you lose as well. Can we please have the witness then brought into court?
I solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Bensouda, you can now proceed, please.
Witness, I want you to recall how you were taken to the military camp. Did you go with these UPC soldiers?
As I gave an oath that I would say the truth and nothing but the truth, I find myself in a delicate position to answer what you have just said.
Can you tell us what you mean by you find yourself in a delicate position? Witness, I want you to know that we are only interested in what happened to you and the truth. So please go ahead and tell us. Did you go to any training camp?
No.
You told the court about a time when you were going home from school when some soldiers from the UPC came and took you and your friends away. Was that story from you true or false?
That's not true, says the witness.
You can have a break, Ms. Bensouda.
Spontaneity! Surprise! There's no proofing that's happening in Lubanga. This is quite a surprise. There's a question I think that can be asked about this, and has been asked, not just me. Would this have happened? Would that have taken place if the witness had met with the prosecution beforehand? Would the witness, he or she, have told them, actually, none of this is true? And then the prosecutor would have had to take some remedies there to discover what is the truth and determine what the witness's relevance is to those proceedings.
Just to make sure I understand this correctly, then if the witness cannot be approached by the prosecution, this was a witness from the defense?
No, this is a prosecution witness, and they had, in the statement earlier on, they had made these yes, statements and signed
but
to
the person that collected this statement was a part of the prosecution,
correct,
right?
correct. And so that's where then later on, but it had been done some time ago. It had been done, I actually don't even know, but some years ago. And so then coming here, there was no intervening interview that elicited this story. Perhaps if it were done in the pretrial stage, it wouldn't have come out either. Perhaps in a proofing session, the witness would not have said that either. We simply don't know what impact that would have had. Maybe none. Maybe proofing would not have done a thing there. Maybe it would, though. I don't know. But I do know that this does demonstrate spontaneity and surprise in the courtroom. You don't see this a lot in the courts here.
But so the teams can approach the witnesses and take as many statements as they want during the investigation, or before they come to The Hague to actually testify. But once they're in The Hague, they can't approach them anymore. Neither can the defense. Right?
Yes and no. There's specific stipulations that occur as far as disclosure deadlines that happen. So disclosure deadlines set at what point disclosure somewhat has to stop before the trial starts. All of the courts exercise rolling disclosure, so you'll be getting disclosure throughout as they find it, as it comes up. But as far as statement taking and actually getting the story from the witness, there are deadlines set by the chambers as far as you need to give this information to the defense so they can prepare their case by this date. Vice versa as well. They set certain deadlines. As far as afterwards approaching the witness, there are different protocols that will then, define whether they can approach them. But generally, if there is no protocol in place, of course you can then speak. That's your witness, and you can speak to your witness. However, if you get any new information or anything's coming up, that then is going to fall under a disclosure obligation. And that's where then they're going to be asked by the chamber, why didn't you have this discussion earlier before that disclosure deadline? We're not sure we'll introduce it now. So it's basically the limits of disclosure that are framing this out. And then that's where proofing is something that's sort of an acceptable late disclosure. Because you can have this meeting where it's allowed and it's understood that new things might come up and the proofing note can go. And it's discussed not necessarily then, as far as that proofing note isn't necessarily disclosure. I don't know where I have the note, but in one of the pieces of jurisprudence, they're actually saying, no, this isn't actually, the proofing note this isn't evidence. We're not having this as evidence. And you'll find that some are introduced into evidence now, but typically they're not. It's typically not a statement, simply corrections to the actual statement. It's meant to be noticed to the parties. It's not meant to be a new piece of evidence when you have this proofing. But sometimes, if it's quite drastic, it can become a new piece of evidence. It just depends what's actually said or what happens in that proofing session. As I said, I don't know. I really don't know. No one knows what would have happened. No one knows what did happen. Well, we don't know what effect that would have. I don't know what effect proofing has had as far as limiting such spontaneity or surprise. When you watch the proceedings, there's very little element of surprise that's ongoing, I find. Typically, the statement is going as expected. You might have some interesting moments on cross of the other side, but it's not anything as dramatic as this. This is quite dramatic, and of course, this is from a movie, so it's set to music, so it's even more dramatic.
What was the time difference between when that statement was given and then when that trial happened?
I don't know the exact time difference. We could probably
Like years
find out,
of
but
time.
years, yes.
Wow.
It's not unusual actually at the ICTY, for example. There are statements that were taken perhaps in 1997, we would have that. And then they're on trial in 2010. That's a lot of time to elapse, and maybe they've been contacted in between, but maybe not. Because typically those statements, those are the prosecution statements, because they're the ones who are doing the initial investigations. The defense are not even assigned. And the prosecutor has multiple cases, so they don't have time to be reapproaching the same witnesses over and over. Usually they'll take the statements, they make this, you have the arrest warrant, the indictment, or whatever the system is, and then it sort of goes into a little bit of a holding pattern. That's why you'll see then it takes longer to revive a trial when somebody does become arrested, because they're like, we have to dust this off, we have to go back and talk to these people. Oh, it's been 15 years since anyone's contacted this person. As part of pretrial, then that's where it's good practice. They can go back immediately and talk to these people. There are time constraints, there are budget constraints, and everybody's facing them. And so I don't pretend to know all the practices or why things happen, but sometimes witnesses are not contacted for years.
Do you think not having witness proofing, like in this case, for example, right? Everyone's been preparing everything, thinking that whatever was in the statement was true. And then you get to this court, and then there's spontaneity, and then it's different. And so then do you think that that sort of creates or sort of engenders more time delays? Because then do, like, the prosecution and defense want to have more time to then sort of, like, rework things and reconfigure stuff?
I think that is one of the things. I mean, like I said, this is really, really a unique situation. They did take a pause, you'll see right there, because you have to figure out where you're going to go with that. We'll take a break. But it's something where, yes, typically that is the problem with the late proofing, and where Judge Bonomy's talking about it, and where even Judge May was talking about it at the beginning in that first passage. The late timing does cause a problem, and that's where when we discuss how you deal with these things, when you get the proofing note, if it's significantly different, that affects the notice you had and your ability to defend your case, or on the prosecution side, the ability to prepare your cross-examination. That creates a delay. Sometimes it's just a day. Sometimes it's a longer bit of time. But sometimes, in practice, that's what I've seen largely, is if you get a proofing note, and it has some new information, or they were shown new documents, they brought new documents. This happens. You'll have a witness show up and, oh, I was looking through my records and I found this. Maybe it's useful to you. They're trying to be helpful, that's great and everything. But then the party calling reads it and says, oh, actually we have to disclose this. This is important, but no one knew that it even existed until then maybe. Those are the type of situations where if you get that situation on the other side in your proofing note, you look at that and you think, well, this is significant. I didn't have notice. It's starting to violate rights. And that's where you're then asking for some manner of stay. But like I said, typically it's been, you get a day or two to then maybe prepare more, to look at it closer with the context of your case and the preparation you've already made. But it could be more egregious where you have a stay to actually go out in the field and do investigations further. Very possible. It depends on what's in there. As I said, we simply don't know, but I know that in the meantime what you have then is a continued preclusion, 2009, 10, and 11 at the ICC. They continue to preclude witness proofing. They're not going to allow it. You have the case of Katanga and Ngajolo, where they're talking about witness familiarization, and when they talk about witness familiarization, they are precluding the parties to meet the witnesses in that time. And ergo, then you cannot be proofing if you can't meet them. This is getting into where you have a code of conduct, as we said, that you cannot approach witnesses. Bemba in 2010, you have, and actually I do have this one, if I can. The majority of the party of the chamber recalls the issue of the party's preparation of the witness for trial has already been addressed unanimously by the chambers of the other court, and by way of explicit decisions on the issue, or implicitly with the protocols, and therefore no provisions for witness preparation by the parties or proofing are adopted. They had a ban in Bemba. They said, we're not going to have witness proofing. Again, this is in 2010 now. We're still not going to have witness proofing.
There is a dissenting of advice, no? From
yes, this is actually, my notes in the next page. But wait, however,
sorry.
Judge Ozaki dissented. You are correct. Yes, Judge Ozaki dissented to this. And that's actually very important to note because I think that's where we have sort of this linchpin to what happens next. She said that proofing may go to the truth-seeking function, and it may set people at ease. And she's giving those considerations, and she's adopting that and says that, yes, this is something that we should be using here. You're absolutely right. So it was only a majority decision, but it was still a preclusion. And that was in 2010. Oh, yes, sorry.
Sorry, the witness proofing takes place before the judges?
No, it takes place with the party.
So there's no one to monitor actually what is being asked?
Right.
So they could, okay.
Unless this is where the videoing and audio recording components come into play and how that could potentially regulate it. But otherwise, no, there's no, and at the ICTY and ICTR, when we discuss how after the break, there aren't guidelines. It's whatever. And are you from the US? Are you from Lebanon? Where are you from? And what is your background in understanding what this is going to mean to prepare the witness?
So has it brought up any issues of misleading the witnesses?
Yeah, absolutely. And that's where then in Hardini specifically, Limai first, you're going to see where they're talking about we need to record these things. And that will then keep people in check. At a bare minimum, if you're not going to ban this, we need to record these. And that's where the discussions about recording take place. But never really come to fruition at the ICTY. It's not mandated typically. Maybe specific sessions might be. I'm never qualitative about anything in international criminal law because there's always one case that something happened and I didn't know. You know, it's like, really? But generally, you don't have to record it. There might be certain witnesses that the chamber says, I don't know, proofing for this guy has to be recorded. It might be individually, but otherwise, no. Typically not.
What's the role of the victim and witness section vis-a-vis the proofreading? Like, where does the role of the VWS in terms of preparation and the proofing is, and what are the responsibilities of the VWS, victim and witness section, vis-a-vis if the witness has been
coach,
for instance?
You're going to go further than that. Bribed, interfered with, any of these things.
I haven't said that.
What is role? I mean, well, I think as a part of the court, there's a duty of the court of the victims and witnesses. If they have information like that, where the witness comes to them, they don't have the same confidentiality. If the witness is coming to them and say, I need help with this, I think that that's the role of them as the neutral body in taking this information. They need to understand that what they're telling, you're not as the victim's witnesses, you're not the attorney, and what you're telling me, can go to the court. I mean, so the courts will then call sometimes victims and witnesses representatives to testify about certain things that go on. That said, there are some confidentiality parameters that you have to respect, but it depends on whether it's interfering with the proceeding. Is it a crime? I think is that line. Is it in violation of Article 70 of the ICC statute? Is it in violation of any sort of contempt 77? Thank you, of the ICTY. Is it in violation of some sort of is a crime? And I think that's where the line is. Or is it not a crime, but is it misconduct? Is it something inappropriate? Is it, I mean, you could have harassment. You could have sexual harassment. Or
leading the witness to certain things and being asked a question rather than being objected because there was a leading question, then it goes in a normal flow and then the witness is answering.
Yeah, and I think that's something that policy-wise the department has to come up with as far as what is done in those situations. And the policies then would be based on what does the court allow. If the court allows everything up until, the actual coaching and saying, you say this, then I think you have to give it wide berth. It's simply that's the way the court works. If the court has adopted a specific protocol or has given guidelines on anything, then you know what those are, and it makes it a bit clearer, I think. And maybe that's something where then, if it becomes an issue that's consistent, the victims' witnesses section as part of the court, or unit, whichever it is, can then address the court as far as creating policies too themselves, just as a blanket measure for the court. If it's something that's becoming a routine problem, it's something to raise internally as a system, I think. Of course, then the parties may have something to say about that, but it's well within bounds to say, we need to know how to act and what are the parameters of the court here with regard to this, because, we're encountering issues. But again, that's up to the departments as far as whatever parameters are in place there. Thank you, yes, for Judge Ozaki with her 2010. Thereafter, though, in Banda 2011, again, we're back to absolutely not. In accordance with the consistent practice of the trial chambers, however, the parties are not authorized to prove witnesses before their in-court testimony. So in 2011 in Banda, again, no. We're still on this wholesale no. And this is why, because it's 2011, people say, oh, there's no proving at the ICC. Because this is quite recent, that this is still a very wholesale ban. It actually says here, it's very, very delineated. The parties are prohibited. Prohibited is a very strong word. They are prohibited from engaging in witness proofing, defined for the purposes of this trial, and here it's defined, so if you're looking for some sort of parameters, the rehearsal of the witness's evidence in preparation for his or her testimony before the court. This is where they're talking then, though, about the context of re-interviews and the timing. You can re-interview them, but then what are you actually doing? And this is where we're starting to discuss not only the timing, but what is the purpose of this? And here's where you'll see that they say the essential consideration is not the stage of the proceedings where it occurs, okay, but the content, namely whether it constitutes a rehearsal of the witness's evidence. And they're getting into that line then about, well, maybe some things are okay. They're saying there's a prohibition on witness proofing, but then this next paragraph seems to ease into it a little bit. It's simply, but what are you actually doing? Are you coaching or are you preparing them? At the same time, in the same period of time, there are exceptions being had at the ICC as far as this goes. It wasn't, while it was a blanket prohibition that was iterated in Lubanga, you had a couple of instances in Lubanga where they actually allowed it. One of these was late disclosure. A document came late, and there had been no opportunity for the party to use this document with the actual witness. In that case, in specific circumstances, the chamber said, okay, for the purposes of this, you can show this document to the witness and discuss it before their testimony. So they're not seeing the document, you know, when they get there that day, and it's the first time, do you know this? And then the in-court time of, I don't know, what's the date, you know, and on all of the, you know, you're trying to see if they even know what this is, if you should use it or deal with it. In those cases, they said that, they have said, unquote, the witness familiarization rules will be waived, and you will be, if you wish for it, given the opportunity to discuss these substantive matters with the witness. This happened in at least 2 occasions in Lubanga where they specifically said, okay, we waived these prohibitions because of this specific circumstance. And expert witnesses, totally allowed. They have treated experts as a different category. It's not the same thing. Expert witnesses often have testified in many trials. They know they're meant to have less anxiety. Maybe they have anxiety, but they're meant to understand the process a bit better. They're meant to understand their topic, and it is something where, because they're a specialty, the lawyers really need to understand and be able to have discussions with them about what's going to be talked about. If you have someone who's a fire expert in there, you need to understand what they're saying, and you can't have a prohibition necessarily about when they're on the stand. You're trying to sort it out as an attorney what they're talking about. You need to be able to have these free discussions somewhat up until the point of testimony. So they've said that with experts at the ICC, discussions between the parties and their experts may take place at any stage prior to calling them. So it's a kind of a free-for-all as far as that goes with the experts. They're a different category. We're almost, I don't know how bad I'm doing. Oh, okay, well, I'll try to be very, very quick here. And then came the Kenya cases. The Kenya cases actually are where we now have witness proofing at the ICC. This is the Kenyatta case and the Ruto and Sang case. This is, if I call this up, you can see they go again over these same considerations. They go over the same considerations that have been discussed for, at this point, probably a decade or more, about what is the value, why are we doing this, should we do it or should we not. There's really 2 schools of thought on this. You have many different opinions about witness proofing, and you see that here. The presiding judge of Kenyatta case, Judge Ozaki. Judge Ozaki and 2 other judges are the ones who then decided, yes, we should have witness proofing, actually. This is also then in the Ruto and Sang case. So you see, that's where that dissent is really critical, because her opinion there then carried over into another case where they actually have the ability, under Article 64, I believe it is, I'm going to be some sort of Roboton with the articles, about the ability to manage the court proceedings. It gives a lot of latitude for the chamber to decide specifically what will happen in their case, and they've said this is what's going to happen in our case. They have said that it's neither practical nor reasonable to prohibit pre-testimony meetings between parties and witnesses they were called to testify at trial. And they decided that it would enable more accurate and complete presentation of evidence, and it will assist the truth-finding function. A lot of the same language that you find in that dissent, you'll find here, as far as the reasons given for why we're going to do this now, actually. Though, because there was already a familiarization protocol that was being employed as far as the Victims and Witnesses Unit section there, because that was already in place, it was sort of negotiating now what is the difference, who's doing what. And this is where I said it turns into a Venn diagram of here's what the Victims and Witnesses Unit is doing, here's what the parties are doing, and here's the middle where it's both, the neutral stuff. And so it's trying to sort out and take those witness familiarization protocols and decide how they're going to integrate a proofing protocol into this or make something new. What they did was they made something new in addition to a familiarization protocol in these cases. And that's actually what was handed out, sent around. That annex, where it says annex when Danya announced it, that was an annex to the decision allowing it. And they set out very specific guidelines about how this is going to go down. And that's what we're going to talk to in the how portion, as far as what this protocol means and how it's being used. To get you to some coffee quickly, it's important to know, and some people in the room will know very well, that this protocol has been applied and this practice has been applied in the cases at the ICC, such as in Uganda, Blegude and Gbagbo, and the Article 70 cases. There are discussions being had as far as whether this should be done or not. In some cases, for example, in the Uganda case, the defense have said it's fine, proofing's fine, the parties have said proofing's fine, though there are some limits. We want different things. We don't necessarily, for example, in this protocol, it requires video recording. Not the Uganda defense team, some people may know, has said, yeah, we don't think that that's actually a practical, reasonable thing to be doing. And also addressing the proofing note requirements, I want to make sure. There's a couple different things that are still at issue. There's no decision yet. We don't know exactly. But basically, it's not about whether the practice should happen. It's about how the practice should happen, as far in that case. Now, if you take the Article 70 case, this is Bemba et al. With the 5 guys who are, I'll call it contempt, but it's Article 70. So if I say that, again, Roboton, I'm talking about contempt case of 5 guys. They have opposed the practice, actually, in a joint defense submission. When the prosecution said, we want to have proofing in this trial, they said, no, we don't actually want it. It doesn't make sense here, because the crimes that you're talking about that have been alleged have taken place in the last 3 years. There's no need to actually revisit this, and this is where the timing comes into play. This is recent. We don't need to have proofing. This is all fresh, and we can go forward without proofing in this case, given the differences from other cases.
So, they say that it has to be completed 24 hours before. Is that common, or is that seems pretty short? I don't know if that's...
Well, there are, if you're considering the cases I was on at the ICTY, there were no limits on that, other than, I shouldn't say that, in one of the cases there was a limit as far as noticing documents you would be using. But proofing could have been done at any point up until they start. You could get a proofing note as they're, basically right before they're starting. Now, you have issues with that, and of course the judges aren't going to take very kindly to that practice, so of course people were trying to do it earlier than that, but 24 hours before was pretty much a standard practice in the cases I worked on. It's simply because of the way that you have to understand that when they're coming in, actually, the witnesses coming in from who knows where in the world, they're not coming and staying a long time here. They have lives, they have other things to do than be here testifying. So they're coming, and also there's, the financial cost of having monitoring and keeping a bunch of witnesses here all the time. You want them to come in, give their testimony, and leave. It has to be very, very finite. Therefore, they come in, they're having proofing, they testify, they go. And so it's all a very short window of time, actually, that happens. And we'll talk a little bit about that timing and how. But yeah, that's actually 24 hours is pretty standard. Interesting here, we'll talk about too, as far as in that protocol, it says that the preparation has to be done 24 hours in advance. It doesn't necessarily say when that proofing note has to come. At least the way I read it. It says the preparation has to be done. So if they're testifying at 9 a.m., you have to be done at 9 a.m. the day before. But, you know, you still have time to draft and send it out, you know. And maybe there's some room for amendment there too, but probably in practice that works itself out. It's also interesting to know that this applies, proofing applies in self-representation cases as well. There's a case of Kotadich here, which many of you will know about. He wanted to meet with Krajnik, who had been a former, he had been convicted and had been a former detainee out at the Undue here as well. So there was the detention unit saying, no, he can't be here because he was formerly detained here and he has an intimate knowledge of the inside of the jail and then also the outside, and so I don't know, it's going to hatch some scheme. There's some policy in place that they can't be visiting each other. But the court said no, for the purposes of proofing, this might be okay. The blanket provision of former detainees not meeting with current detainees might not apply here because he needs to be able to prepare his case. So you have to look that it even applies then, proofing goes on in self-representation cases. At least it has here at the STY. And I just want to make one quick final note here on the who of it, who's proofing. Both parties proof. The prosecution proofs their witnesses. The defense, whoever's calling a witness, the defense proofs their witnesses. At the STL, you have the victim's representatives can proof their witnesses when they're calling witnesses. This is in a decision that occurred actually very recently. I think it was last year, maybe. But the victim's representatives who are calling witnesses can proof their witnesses. The one that's a little unclear still is what about chambers witnesses? Because the chambers do call their own witnesses sometimes. It happens in some cases. Who's going to prepare that witness when the chamber's calling the witness? In practice, usually no one. Usually the chamber's calling the witness. They're going to have sort of, it's almost the proofing session there. They're not engaged in it in the same way. If they're calling them, it's usually because a party was going to call them and then didn't, or it's something that's come up that they specifically want to get at. Typically, the chambers has not done this, but as I said, I would never rule anything out and be very qualitative about anything. It could happen. You could have the chambers proofing their own witness if this came up. I mean, I don't see what would prohibit that. But I've not heard of that. Maybe someone else has, but I've not heard of that happening. And simply because they're very finite issues, or they have statements already from the others. It's usually a very specific situation if the chamber's calling their own witnesses anyway. So that would be the who on this. As to the how, I think we can do that after coffee, since it's warm and I've been yammering on for about an hour and a half now. So
yeah, so we have coffee and tea coming and some cookies. And just a question, if you could all please sign, there's a sign-in sheet so we can get the certificates on Monday. Yep.
Minnesota?
Okay.
You?
Arizona.
Actually, that's where I spend my Christmases now.
That's a good time of year.
Which part of Arizona?
Phoenix. Yeah.
Where did you say you were from?
Minnesota?
Okay, I'm from Florida and now I'm law school in DC.
Oh, nice. What law school?
Georgetown.
Oh, okay.
What part do you spend Christmas in? Is it Phoenix area you say, or it's people I feel like people know, but I hate to one of the two.
Yes.
No. Your name?
My name is...
Somebody has in
Do you work at the ICC now, or still here, or?
No.
Oh, wait, sorry, that was me.
I'm in CSS.
Oh,
okay.
Will you?
As an intern.
Yes,
I'm
sorry,
sorry.
like,
We travel part of the place, so we haven't met, Henry.
Michaela. So I'm just there for the summer, but
No problem.
Very nice.
Oh, sure.
it's been a great experience so far.
Good.
It's interesting seeing how it all comes together.
We're busy right now. So,
Yes, lots going on.
definitely.
It's about like CSS always has a lot going.
Court's very busy.
Feel free.
Yeah, there's lots of. I'm getting to learn a little bit about everything.
That's fantastic. Yeah, really.
You're from?
أنا من إسبانيا.
Where?
أنت؟
That you speak Arabic.
لأن أنا درست في المغرب سنة واحدة كلية حسن الدين. أنت تتكلم العربي؟
No. Because I'm Lebanese.
نعم. ولكن أنا درست نتكلم دارجة في اللغة العربية الفصحى. قليل.
جيد.
نعم. أنا درست اللغة الفرنسوية.
سي.
نعم أنا درست في فرنسوية. القانون الدولي.
Okay. Coffee. How we can use it.
Oh, how are you?
It's so complicated.
Good, now that I have your breakfast.
You can help us for the coffee.
Just hot water and coffee here.
Okay,
Sorry.
You will help me?
Yeah. Oh, yeah.
Oh no, that's perfect. Yeah. Okay, that's ideal for this. Otherwise, it would have been missed on the certificate.
Yeah, that's why I was like, yeah.
No, I just hate it. I don't know.
Yeah, they're like,
Yes. Oh, thank you.
Antonio.
That's a Spanish name.
Yeah. You're right.
I think I'm going to take this.
Oh, really? Stay there?
I'm not
But yeah, and then
And yes, sorry.
So you are going to do a lot of
All this as well.
Okay.
She's the one taking care of the but she's not including
Maybe you should have another one.
Yeah, these cups, like, it's so hard.
Actually,
Good.
Where are you?
I mean, now that
Where?
Yeah, me too.
I want nicer more weather, but I'm not sure.
Okay.
Are you working with
You?
Yeah, I'm working with Russian. I work with the Russian.
Which one? And
Yes.
The Butari case for SDR, and then I'll be like, but it's a really big case. There's 6 accused.
No. The way they said I literally walked around and I walked like down the block and I'm like, I can't do this.
It's super good one. Yeah. And then my judge also presided from our council. I think so I didn't know. I didn't know that when I a bunch, like some like there's a lot of things that come to me that are not
But then I went to school in upstate New York, by Syracuse actually.
It's like there's been a lot of
by Drive. So it's like one of those upstate schools.
With the system
Even in the middle of the summer. And like,
What are you working on?
So we get them to divided here like this. And then it's, you know, we really put it rain. And that's already why they started 8 p.m. was the training.
and then I have a contract with the team.
It's so
Where are you? Canada. It's a French part. Where do you Okay. Which in Windsor? Yes.
I like Windsor.
Too much. There and then Windsor in a year.
Interesting. There's another name in my other friends. So we need like chambers person and then
It was nice in New York. It was nice in the morning. Like consistency, right?
But it's well, I'm from like, I mean, I did my studies in Quebec City, and my parents are from Canada, so I think we're connected. Yeah, of course, yeah. It's different in Montreal. The
You don't like that?
You don't have the time.
Well, yeah, I think she was doing some of her defense. And she was able to go to that.
I don't know my work for an English department.
I mean, they don't even give interns confidential. Some of them are already and then some of them
but in the end, it's everyone's opinion, right? Yeah. Are you
but I'm very touching this
It's always easy to
when you were having and you can like, but can you understand what you're saying? And the guy sitting here, and the guy from you know, it's show me around a little.
I don't know. One word is beginning and but for most I can get around it.
You remind me of with only 9 months of burning.
It was every day.
Okay. Like, yeah.
I had so much homework.
I was like 9 months of but then if you do 24/7. When I met her, she was always like touching
some really basic stuff.
But how old were you when you looked at me?
You cross Belgium driving 6 hours. I think it's ridiculous. I don't know. I live like even here. I'm with the bus. Yeah, one of them my really get it at first, you know. One country Dutch and maybe
And like you can like bank on the plane. And it's a 10-12 hour flight. So I think it also said what destination. So I tried to say you get to travel with your
How do you see that from the...
No, I think everybody knows UCLA. Everybody knows. I'm pretty. You can have it in your head. They're like, so I'm always thinking about those, but then like, and they're not so I'm always thinking this so I'm always having a lot of positive stuff, and my supervisor we don't ever just give it. We had a team. I found out in comparison to like, and I was thinking, a week before, and that's when you just visit the magazine. You were great. I think it was that's what you have now. I guess no, I think it's sorry. No, I know.
Yeah, the last two are very fun.
You're
It's very fun to play.
What?
I think it's sort of sometimes so
Yeah.
but it can be a little bit.
Yeah.
But something like
Yeah, a lot of times.
Hello.
Understanding that stuff. Violating that. Yeah, but and they're interviewing, not the supervisors, but I'm telling them like, no, they
How do we do this now that we're kind of talking about the why? And I don't know if everyone's in agreement that we should, because I think this is still, again, something where there are a lot of different viewpoints as to what value this has and what the limit should be. But I think we should talk about that in a little bit. But first, let's talk about how it generally is being done, so we have an idea. We kind of know from a bit of the discussion, but it really is, this is the difficult part of this training, I was thinking. It's so subjective. It really depends on the case. It depends on the witness. It depends on the counsel and the team and what their background is and what their expectations and their own code of conduct. It depends on the court and what parameters are set there. The specific chamber, are they allowing it or not? Everything. It absolutely depends on so many factors as far as exactly what process. There's no one process. The same way that you'll go about interviewing witnesses generally, there's different ways of doing things. There's different ways of doing all of these things. So this is an incredibly subjective topic that we're working on here. And there's loads of gray area, as we talked about earlier, from this end to this end. In the U.S., though, where we were talking about how we're way over here, there are actually limitations on this. You can't be coaching witnesses. And this happened actually in the terrorism trial of Zacarias Musai. If you followed that at all, actually. There was one party who gave testimony of other witnesses to the witness and advice. And that was found to be over the line. And this is something where it got a great amount of commentary from people in the field who were talking about what are these limits. And you found a lot of different opinions. I thought this was very interesting because you had one law professor who said that the difference was like the difference between dusk and twilight. And I think that's nice and poetic. And it is sort of that line of when you're getting a little darker in the sky and how dark is too dark as far as going through this. But that same bit, and this is in several articles actually, that you can find these comments. There was a former federal prosecutor who said that the line is clear. This is pretty clear. Okay? They said it's proper to share the questions that you'll ask, but not the answers you should give. That's clear. You can show the documents to refresh the recollection. You can do a mock cross to draw out any vulnerabilities. But you cannot, and this was what he said, to recite, much less transmit wholesale the testimony of an earlier witness. You would never say, so-and-so said such and such on the stand, is what this person had said. It still is getting into some gray area, I think. I don't think it's as clear as he says it is. It's clear to him. He knows what his lines are. And that's where, again, you're in the subjective practice. This man, this federal prosecutor, has been doing it for decades probably, and he knows exactly where the lines are for him. But that doesn't necessarily mean that his lines are the same as your lines, or the court's lines, or the witness's lines. So this is where it becomes a very muddy area that you have to make sure that everyone is clear and on the same page about what's happening here, so you don't get into any trouble. Because there is a lot of ethical ground here to be covered as far as you have to abide by whatever parameters are set, not only by the chamber, but by the code of conduct that you're practicing under. The ICC, they say that this code of conduct takes primacy over all other code of conduct. But, as you know, you're licensed in another jurisdiction, you have to abide by that code of conduct as well. So you have to make sure that whatever you're doing is abiding by all your proper licensure. And sometimes there can be conflict and it can be difficult. But that's where you have to set the standard for yourself. And again, where even if it is permitted, maybe it's not permitted in the same way for you as it is for others if you want to keep the license back home. I don't know. That's up to you in your own jurisdiction.
How do you then overcome that? Because if you practice in a jurisdiction that doesn't allow any of this stuff, like let's say Lebanon, right? That was an example. Mm-hmm. And then you're here, and you're working in the ICCY. And
with the STL.
Yeah. Then what do you do?
What do you do? I don't know. Are there good answers? I mean, I don't know if you've come to any consensus in your own mind or comfortable, I don't want to put you on the spot, medium on this, but I think that you really have to make sure that you're just simply not violating your own, and you have to figure out as far as where this Lebanon Tribunal is very interesting because it's applying both laws too. So that's where it gets extra muddy in my mind as far as the code of conduct. Then of course if you're applying the law there, then the code of conduct is applying there, and where they're in conflict then, does the STL code of conduct say that it has primacy also? Or how do the two work in play?
The Defense Office concluded an MOU with the Ministry of Justice in Lebanon.
Okay.
And there is an exception for the STL Council to be in contact with the witnesses. So actually we are not facing problems.
Okay. Excellent.
But we are facing problems with the mentality of the Lebanese witnesses.
Of course.
Because before contacting them, they call their lawyers in Lebanon. Oh no, you cannot be in contact. So they ignore the STL rules and the STL deontology.
That's very interesting because they don't necessarily know that that MOU is in place. But that's all. So where then you have to look to your local bar and whichever bars. And here that's excellent. The Defense Office has taken this into consideration and then has made some provision, understanding that you are going to be facing a problem there with
and
both.
The Beirut bar as well is not so satisfied about this MOU. Every 2 years we have a new president of a bar with his council. So if the council is pro-STL, it's okay. If not, as well, yes. So this is an MOU, this is not a convention, so the primacy of the Lebanese law.
So every 2 years you revisit.
Yeah, so tricky.
Okay. Yeah, I mean, it's not just gray. There's not even a color to describe.
So actually, we are good because the president of our bar, it's okay with the tribunal.
Okay.
Yes.
So right now.
Yes.
For now.
So from those people who wants to prosecute the accused of Hariri assassination and tell.
Okay.
Yes.
So for right now, you're okay.
It's not the case. So. For my case, I'm okay. Yes, and the content case also, it's so difficult when you are treating with journalists. Yes.
Yeah, this is a very good example. Thank you so much for that, because I did not know about the MOU, but that's a perfect example of how it's very specific to whatever situation is going on. And especially where you have two different, like a domestic code and the code here, there are a lot of times that you might need to get an advisory opinion from a bar. You might need to, have a defense office step in and help you with these things to sort out for you. It might not be something you can do on your own to figure out, I'm okay with this. You might need something that's going to ensure that this is actually okay.
As well, if you can allow me to tell you that we are facing several problems, meaning we don't have instructions from the accused, from the clients, especially in absentia cases or in contempt cases when the accused is refusing to cooperate with the council or with the tribunal. So you are contacting witnesses without the instructions of the accused.
Yeah, thank you. You have so many unique issues there as far as how to deal with ethics. That the proofing issue is one of many. See what we're doing to assist.
Really, I'm here to learn to see how it's working with other tribunals.
Okay. No, thank you very much for that. I mean, you have so many different facets that you have to factor in on this. You don't have a client to take instruction from either on how you're supposed to be proceeding in absentia trial, which, that's a real factor as well. I think that it is interesting, and thank you so much for that, because it is interesting that how you have to really sort these things out, and it does become personal to wherever you're barred. I'm barred in the U.S., so and in a specific state, I have to figure out with that bar then how that works with this code of conduct if I'm practicing under that, or the ICTY's code of conduct if I'm practicing under that. There are many different ones you have to sort out exactly what you're under, and how it all works out. And in my case, if I had any question, I would ask my bar at home. They're the ones who licensed me. I would ask them at home. I'd probably ask the ADC if I had a question about ethics. They have a board who can give advisory. If there's another bar, you can ask people for opinions. Ultimately, then, it may be something also that needs to be taken to the chamber. If it's something where they said witness proofing is okay, but then one side is not allowed to do it, or one party's not allowed to because they're restricted by a domestic code, then that's not equality of arms amongst all the parties. So that's where, again, that's something you might be bringing it to the chamber and saying, look, we can't, so if we can't, can they not either, you know, because you need that equality in the parties. So you have to look at different remedies. It's such a subjective thing based on what the specifics of the case are, where you're at, who you are, and what you're dealing with. But yeah, that's a very interesting example, and thank you for that question. As far as the criticisms go, we were talking about this, there's a risk inherently of witness training and coaching. There's a very good quote here. It says, an honest witness may alter the emphasis of his evidence to accommodate what he thinks may be a different, more accurate, or simply better remembered perception of events. What we're talking about here is we're not talking about the coaching where this woman sent out the statements and said, you should testify like this, or maybe you should say this. We're not talking about the clear-cut examples of coaching. It's where you're alluding to something, and then maybe somebody gets the idea, and now have you crossed the line? What if your testimony were something along the lines of this topic? Or maybe you should talk about this, but the way you phrase it is influencing what they actually say. Now you might be over the line. You might be coaching. This is why it's very difficult. You didn't tell them, say so-and-so was here on this night. You didn't say that. You said, but what if so-and-so was there on that night? Is that over the line? Big nods here. I think it's over the line. I don't know. I mean, there are people who might not think it's over the line. I fully believe most people will think this is over the line. But there are some exceptions. Some people might not think that. I mean, it is a gray area of suggestion and coaching. They might say, I didn't tell them to say that. We were just looking at some possibilities as far as what might have happened that night. There were several. But there's that line, and if it comes to litigation, then of course a decision will be made on that. There's a very good movie. I don't know if you know of Anatomy of a Murder. I love Jimmy Stewart, so this comes in very nicely because we're back to that the partially dissenting opinion of Judge Ibo Tsuji. This is it. It's a hefty little piece. But if you look through, he goes into great detail in his dissents and concurring opinions, typically. Even he refers to this movie. Because there is a scene here that is well noted for, and this is in the context of a client, but is well noted for, are you improperly making suggestions? And this is where you're doing it with a client. He's a client he's meeting. And he's talking about it here. It's discussed many times, but he actually, as you can see from the footnotes here, if you can see, he's put the script of the movie in the footnotes even. I was telling her, I think there should be an annex to this that actually has a video clip, because I think it would be more fun as far as decisions should now have some sort of video clip. But I figured since it's in this decision and it's talked about a lot as far as where's that line of influencing instead of telling, why don't we just watch it, because it's only about 2 minutes long. Again. If I manage to find it also, because I had it on YouTube.
Hello there. I usually answer to the name Paul. You gonna have some more jokes? No, not unless you want to be the comic. Oh. I brought you some cigarettes. Oh, thanks. Peace? Oh, sure. Fine, fine. Now, Lieutenant, there are 4 ways I can defend murder. Number 1, it wasn't murder. It's suicide or accidental. Number 2, you didn't do it. Number 3, you were legally justified, like the protection of your home or self-defense. Number 4, the killing was excusable. Well, where do I fit into this rosy picture? I'll tell you where you don't fit. You don't fit in any of the first 3.
But why? Why wouldn't I be legally justified in killing the man who raped my wife?
Time element. Now, if you'd caught him in the act, the shooting might have been justified, but you didn't catch him in the act. And you had time to bring in the police. You didn't do that either. You're guilty of murder. Premeditated and with vengeance. That's first-degree murder in any court of law. Are you telling me to plead guilty? When I advise you to cop out, you'll know.
Cop out?
Well, that's plead guilty and ask for mercy.
Well, if you're not telling me to cop out, what are you telling me to do?
I'm not telling you to do anything. I just want you to understand the letter of the law.
Go on.
Go on with what?
Whatever it is you're getting at.
You know, you're very bright, Lieutenant. Now let's see how really bright you can be.
Well, I'm working at it.
All right, now because your wife was raped, you'll have a favorable atmosphere in the courtroom. The sympathy will be with you, if all the facts are true. What you need is a legal peg so that the jury can hang up their sympathy in your behalf. You follow me?
Mm-hmm.
What's your legal excuse, Lieutenant? What's your legal excuse for killing Barney Quill?
Not justification.
Not justification.
Excuse. Just excuse. What excuses are there?
How should I know? You're the one that plugged Quill.
I must have been mad.
How's that?
I said I must have been mad.
No, bad temper's no excuse.
Well, I mean, I must have been crazy. Am I getting warmer?
Okay, so long, boys.
Am I getting warmer?
Well, I'll tell you that after I talk to your wife. In the meantime, see if you can remember just how crazy you were.
So this is called the lecture, and this is talked about a lot as far as what sort of influence you can have when you're not directly saying anything, but you're obviously influencing things. This is so famous in this regard that it is discussed then in this partially dissenting opinion, actually. If you want to go to it and read it at great length, we don't have time to read through the 23 pages of single-spaced right now, but it is discussed, and with actually this transcript in there, because it is something where this is very much more clear-cut, let's say, compared to where you may not even know that you're influencing testimony when you're not even trying to. You might be suggesting things just because you know the case and you know where you want it to go. You might be actually alluding to something that you are not even thinking about, that you're giving off hints and signals. You have to be very careful that you're not putting anything into that witness's mouth, that you're not telling them or even suggesting how they should be answering. And that's where you get into some real dangers. Especially when the witness may ask you, well, what should I say? How am I getting warm? This is, you have to be clear with them. I cannot tell you what to say. We want the truth. We want your honest answers. We want your recollections. And you have to make sure that this is very clear to them, that this is not about what you want them to say. The only thing that you want to do is control. We're not going to talk about your Aunt Edna baking a cake 5 years before the incidents happened on this day. It's not relevant to this case. We're going to talk about this day and what happened, what your experiences are that day. That's where you're limiting. That's where your wants are being put here. And they're not your wants, they're the wants of the whatever the trial parameters are. Your wants don't come into it as far as what they say at all. And that has to be clear because witnesses don't necessarily understand. Maybe they think that that's what they're meant to be doing. So you have to make sure that you're the one who's in charge of it and make sure that you're the one who's communicating properly here. And check yourself on these things, that you're not accidentally doing anything like that. This is not accidental, obviously, but you could be accidentally doing something. So how should it work? Like I said, at the STY and ICTR, there are no guidelines, really. There are some decisions, specifically in Limay and Hardinay, where you have some recording or you have some parameters that have been set. But otherwise, it's sort of up to the calling party, however they want to proceed. That has changed with the ICC, and that's what we handed around, the annex, as it were. This comes from the decisions that we have actually here, this 524. If you look to this annex, I think if you have one in front of you,
Yep.
it might be good. We can just go through some of it because I think, no, if we go to the very beginning, this first section here, this actually is laid out. When I started going through it myself, and you'll see my notes, this actually lays out nicely. It's why, who, where, when, how, and then the second section, this required and permissible conduct, you get to the have to, can do, should not do. It's very clear as far as the way it's structured. I think it's actually quite nice as far as setting out some guidelines. At least structurally, this makes sense as far as if you're going to be looking to your guidelines. As far as the actual pieces of it, that's where you have some litigation as far as in cases now, if certain provisions should be changed or not, should you have video recording, what's going to happen with the proofing note. And this is just starting. If they're going to continue to use this, you'll see more litigation. Different teams will have different needs and wants, requests, but this is right now the general protocol that's being used for the Ruto and Sang case. It would have been used in the Kenyatta case had it started. The general principles at the very beginning, this is the why. That section 1, that's why. If you look to it. That first one, it says the purpose of witness preparation. They're telling you why we're going to do this, actually. They're ensuring that they give relevant, accurate evidence to make sure that the well-being of the witness. This is the anxiety concern that we were talking about. And they're also talking about, in Part B there, of how focused, efficient, effective. This is all in Section 1 of the general principles. That's the why. Why are we even going to do this? It's in here. This is why you're doing it. You can see in point 2, it's not for a new statement. See point 3, we are not coaching. It's coaching, training, and practicing are not allowed. Practicing, these are vague terms too. Practicing, what does that mean? Does that mean you're going to give them the questions and they can practice answers? That would be allowed in the U.S., but is that allowed here? Is that practicing? What does that mean? Or is it only practicing when you take the answers? There are some things here that will obviously, as they go, be litigated. And are probably litigated in the Ruto and Sang. I simply don't have any of the jurisprudence on that, only because it's probably, if there is any, it's probably done in a confidential manner because it's dealing with the witness proofing. I have not seen it publicly yet. But I think that's where in this you would have lots of discussions. You could see where practicing might not be the most clear. But they have to also make it somewhat general to allow for all those subjective concerns. And number 4, it has to be done under standards. These are the code of conduct, if you see it, or conduct, it's plural if you have more than one. The second section here, the responsibility for conducting witness preparation 2. That's the who. Who is in charge of this, actually? And it's the responsibility of the calling party. Who is going to do this? It should be done, they specify, by the lawyer who's calling them, who will be taking their testimony in court. So they're being very specific here in this case. They're saying, if you're the one who's going to be questioning the witness in court, you're the one who does the prepping session. It's not going to be somebody else and then you hand over to this person, which can sometimes happen. They want specifically the lawyer who's going to be in court with that person. This probably also goes to then later, if any issue comes up, then that person's on hand and they can discuss it in the courtroom. You don't need to call somebody else in and figure out what happened. Practicality. But also point 7, they need a +1. You need some sort of witness or someone there too, so it doesn't turn into, if there's no recording, a he said, she said, or he said sort of a situation where there's only 2 people and maybe the witness says, no, they told me to say this. Well, it's a good idea, good practice generally in dealing with any sort of interviewing situation to have a second person there, simply to make sure that there are other people in the room to verify maybe this happened, maybe it didn't, if called.
Should he or she be from the same party or an impartial court?
That's actually interesting because they have discussed whether VWU can be involved in it or not in some of these. And typically what they've said is, the neutral registry shouldn't necessarily be there. This is the calling party's interaction. So typically I would say by those guidelines it should be somebody from the prosecution office, and if it's the prosecutor calling, if it's from the defense team. But having someone else there.
But always there are video records who are...
Well, That's, we did somewhere in the record keeping, that's .5 here, that they do that. But here, where you don't have a record, where you don't record at the ICTY, I think it's just good practice that at least 2 people would be involved in that session, especially because you don't have that video to rely upon later. If you have that video, yeah, you could say, well, there's a video, it's one-on-one, but here they're specifically saying they want one other person there. Unless there's also a caveat, exceptional circumstances render this impossible. I'm not sure what that would be, but there is a caveat that if one person does it, maybe it was for some reason. It had to be that way. Did you have a handout?
Maybe when the protected witness?
It's possible, though, I would think it would be more about a vulnerable witness who might feel overwhelmed having 2 people, you know, asking them questions in some sort of situation like that. That might be where it's an exceptional circumstance where you have a one-on-one proofing session. But in here where it's video recorded, and maybe if there was no video requirement, they would say, okay, you can have one-on-one, but that one is videoed because of that reason. I think so. Yeah, I think protective measures not as much because usually the whole team will have access to that. But definitely, yeah, you're on the right track. With vulnerable witnesses, definitely, you could see where that might be the exceptional circumstance. Thanks. Location, where? Now we're on the where. It should be done at the seat of the court or at the place of testimony, if elsewhere, or any other place. Anywhere. Anywhere. Point 8.2 says absolutely anywhere. You can do this wherever. But, point 9, you have to ensure security. Make sure that you're in a secure location to be doing this. So, anywhere but. Timing, it's the when. When do we do this? Now, this is critical if we look to that jurisprudence as far as when we're going to do this. And as you pointed out, this says that you have to do the preparation sessions as early as possible, it says. And that's language that comes from that Milutinovich decision or some of these earlier decisions of other courts saying as early as possible. Let's be practical about this. But, in any event, at least 24 hours before the witness's testimony is due to commence. So it says that you have to complete the preparation sessions at least 24 hours in advance. Again, that doesn't necessarily say what you do with any disclosure that comes out of that, any new evidence that comes up, any changes. That, to me, by reading this, doesn't fall within that 24-hour window necessarily. Now, in practice, maybe they've required that. I don't necessarily know in trial to trial. They might say, though, we read that as actually you have to complete. That means you're done and you give all disclosure 24 hours in advance. And what does 24 hours in advance mean? If it's Monday morning at 9 that they're testifying, so Sunday morning at 9. Yeah, and then they can send some disclosure on Sunday afternoon. And I mean, this is not unheard of. These are 24-hour courts that we're working in. But it's also not the most convenient construct to be getting, you know, some sort of proofing note on a Sunday morning at 9 when you start the next day. Actually, maybe it's more convenient because you don't have the sitting session during the day. I don't know. But it is one of those things you have to look at, actually. This is as early as possible. And that takes definitely from that language in Milutinovich. Here, the how. The next section is how. The calling party shall video record this. They're requiring that these all be video recorded. They also have to keep a log of each preparation session. This is on page 4 at the top. The preparation session actually says what has to be in there. They have to list where this took place, how long, and who was there. There's quite sporadic practice at the ICTY. We're going to look at a couple different proofing notes as far as some of them give that information, some don't, some give a lot, some don't. The format, what they call it, it varies. Here they say specifically you have to keep a log and you have to say where were you, how long did it go on, and who was there. And how long did it go on is important because sometimes these go on for a day or 2 days. I mean, these can be extensive proofing sessions. It depends how much testimony they had. Maybe they testified in 3 different cases and they have 5 statements and you're trying to figure out exactly what testimony is going to show up the next day in trial. There's a lot of sessions that go quite long. After conducting the witness preparation session, so when that's complete, if we go back to that other one, the calling party shall promptly provide the non-calling party with a copy of the log. And this is that point of what does promptly mean, and it says after they're done with it, so that's the completion. So that then, to me, could easily fall in that 24-hour window. You might still be getting that proofing note the night before, a few hours before. But again, that's something that chambers usually will not look favorably upon. If you say, I just got this, it's a totally different statement. Usually you'll be allowed some time to prepare if you bring that to the judges. They know that that is not ample notice, or it's not effective use of time to be in the courtroom when you've prepared this, and then now you have to try to wiggle in this over here. So oftentimes chambers will then say, okay, we'll take a break in this so that you can go and look at this closer, and then we'll come back and reconvene, maybe the next day, maybe not. This section 6 here, required and permissible conduct. This is the, how do we do this in the ethical sense? Where are these parameters that we're talking about? What do they want at the ICC? They've divided it into 3 sections: must, may, and shall not. It's very clear. I think they're quite interesting. The must, they have to reiterate the obligation to tell the truth. So this is a good way to start, so they understand, so the witness knows why they're there. They're there to tell the truth. Start there. That's a good start. Explain the purpose. Why are you doing this proving session? You know, I already gave you a statement. Why am I talking to you again now when I'm talking to the judges and everybody tomorrow? Give them an opportunity. They must give them an opportunity to review that prior testimony, so they're not caught out necessarily where there are mistakes that they didn't necessarily contribute to. Maybe it was just the process. Something happened, or somebody misrecorded a number. They have to have the opportunity to review those and confirm whether or not those statements are correct or whether they require any changes. Those are the things that have to be done with witness proving sessions in these cases when this protocol applies. During the preparation sessions, though, the lawyer may. Now here's where there's some permission to go for those different jurisdictions and where people's interests or guidelines lie. They can, in general terms, it says, very specific, in general terms, they can talk about the topics they're going to cover in examination in chief. So we're going to talk about the 3rd of August, 1994, if we're looking at this packet of information. We're going to talk about events on that day. We're not going to talk about other days. We're going to talk about this day. We're going to talk about the events in your statement. You can talk about generally topics like that. That's permissible. They can explain in general and neutral terms the topics that they may get on cross-examination. And you'll notice it was just general for examination in chief. Now it's general and neutral. They have to be neutral about what they think the other side might question them on. And this might be where, well, you know, you have 4 convictions for murder. They might ask you about that. General topics. They might be wondering about that, actually. You have been found guilty of fraud. That might interest them. You know, things like this. Generally and neutrally, though, this is where they're requiring that. That, to me, would signal that we're not then preparing them, again, not coaching on those situations. They can explain that they may not be questioned on the court on matters upon which investigations previously questioned the witness. To me, this may is very permissible, but basically it's that, to me that's sort of a judicial duty, in that if they're covering area that's already in evidence, the judges will usually stop it because they don't have time for this. They have to move on expeditiously. But they can explain to the witness if you've gone over this and this is already in evidence, that they cannot be questioned in court on that. Though, to me, you might have some trouble then because the witness might not be the arbiter of that and understanding what the relevance is to any specific questioning and what can they do about it anyway. Then they might become that witness who's saying, you already asked me, judge, you know, tell them to stop asking me that. But that and then devolves into not a desirable way of having your witness on the stand necessarily. But again, that to me goes more to the, you can be talking about what are the general areas that you're going to be talking about and what's not included. You can show them, you may show them exhibits and talk about exhibits. To decide, it says here, the utility. So it's showing them, now, have you seen this before? You know, you talked about this in your investigation, okay. You know, do you have any comment on that? You said this about it, is that accurate? You can show them those. Or this, we've recently come into this document, you know, and can you review it, please? And see if they come up with anything for you on that. You can explain the role of the various participants in the courtroom. This is something where you're going to want to know what's already being explained by the victims and witnesses unit or section. You don't really need to reiterate and waste your time if they're getting a very hefty briefing already, if they're getting a courtroom tour. You don't need to do that, but you can do that. They said that's fine. You can do that if you want to. You can inform them about appropriate witness behavior, and I think as far as then in the U.S., this is something you have to do necessarily. Don't argue with the judge. You're there to answer questions. You know, you are there. They're taking your truthful advice. there, you have to answer the questions. If something is going wrong, or there's a question that's not proper, an objection may be made. The judges will take care of it. Help them to understand the roles that other people are going to play in the courtroom to make sure that the parameters are okay with their testimony. It says here also, including the need to speak slowly and concisely. And that's I have only may, ? Because I think that's also quite important. Explain to them, because they're going to be told about what they call at the ICC the golden rule of 5 seconds. They don't call it a golden rule here, but it's the same. You have to wait until they're done speaking. We have interpretation. We have to wait, and then the next speaker, when you're speaking the same language. It does not come naturally, so I think it's something that's very good to tell the witnesses. Explain that interpretation is going to take a little time. It feels unnatural because you're waiting, but you have to make sure that everything is recorded properly. So I think that while that's only a may, I think that that's a very good thing to make sure that they understand how that works with interpretation. Because it's not, I still will roll along. I have a hard time remembering it, and it's not something that comes very natural. Anyone who's been in the courtroom knows there can be long pauses that feel very unnatural, simply because you have to make sure that it's all being recorded. And you're not driving the interpreters bonkers with, racing and overlapping comments. And then subject to the restrictions below, they can answer any questions they have about what to expect in court. But subject to the restrictions below, because the witnesses might ask you something you can't answer to them, because you might be getting into your own ethical violation. Prohibited conduct must not do these things. You should not seek to influence them, either directly or indirectly. So make sure you're not indirectly influencing by saying something. You might think it's a peripheral comment, but you can actually influence people when you're not even trying to. So make sure that you're not doing that. It's the same sort of a thing when you're taking an initial interview. Anyone who's had any interview training, make sure you're not, influencing your own ideas into when you're taking that. You want this to be as neutral as possible, getting the information from them, not putting the words in their mouth. Don't undertake to train or practice the questions and answers. They're specifically saying here, you should not practice the questions and answers so that they have a memorization of it, actually, and they're saying it in rote. But if you're talking about here it's talking about the questions and answers, and it's talking about memorization. Again, in the U.S. system, you would be able to, I'm only referring to it now because it's, end all be all, but because this is what I'm familiar with. In that system, you can tell them what the questions are going to be. Not the answers, though. So here it's talking about, it puts them together and it says, you can't practice the questions and answers. If it said or, that's a different thing. Then you can't tell them the questions either. I'm not entirely sure how far the prohibition goes here. And that's something that then maybe, again, litigation might come up or questions might be asked about that later. And you cannot inform them about other witnesses or other testimony that they've given. That's influencing because it's telling them what other people have said, and it's suggesting to them what might be the right answer. People are very suggestible. I'm very suggestible. Everyone is. If somebody said, well, that was already said, you think, well, wait, maybe I got it wrong. Unless you have great conviction. Okay, but it might influence you to think, ooh, maybe the date was wrong on that. You cannot tell them what's going on with other witnesses because it's just too much of a risk. And that's often why many domestic courts will require sequestration orders. They cannot see other testimony of witnesses. And that will come up. You can see here a question sometimes in cross. Did you speak with any other witnesses before you gave your testimony? The reason that happens is because maybe they were, having influence upon each other, even if they weren't meaning to. It wasn't maybe necessarily with any malice. It was simply that they were, I heard that, me too. It might be influencing where you're not even trying to, just having, a discussion over coffee. And where the calling party finally obtains information during the preparation session that is subject to disclosure, it shall disclose that information to the non-calling party as soon as practical, and in any event before the witness begins his or her examination in chief. Again here, this is where I feel like this 24 hours is only for that prepping, because it says in any event before they start their examination in chief. So the disclosure to me then, starting it is when they take the oath. So if they're taking the oath, 5 seconds before they take the oath, you can disclose the document. You're going to get in trouble if you do that, but it would be permissible by this standard as far as technically. Yeah, exactly. But if it's new disclosure, yeah. You risk, basically, the later you disclose it, is with any disclosure rules. This is subject to all disclosure practices. That's a different training that we can't get into disclosure right now. But you're going to risk not being able to use it if you don't disclose it properly, so that they have an opportunity to review it and use it. And there's all sorts of, I can't even begin to start on the disclosure rules that apply to all the different courts and chambers and everything. They're just going to be whatever it's set in your trial. You have to know those and abide by those, including with proofing.
I have a question regarding witnesses talking to each other, actually, because I'm working currently for a judge that presides over SCTY and ICTR cases, but what I found in some of the trial decisions and stuff that I've been reading, because I'm in the appeals chamber, so we have to go back and look at everything, that witnesses have talked to each other. And so how do they, are there rules that sort of, cover or deal with, when the witnesses come here, like you said, they come maybe 1 or 2 days before they're going to be giving testimony, and I know these trials take a long time and everything, but maybe, I don't know if they're ever here at the same time. How is that monitored?
It's not, I think is the short answer. I mean, these are a lot of times small communities, and I grew up in a small community, and, everyone's in the same, cafe in the morning, and they're talking about the same thing, and this happens. I mean, these are not small little events. This was, earth-shattering stuff that happened in a small place often. So you're going to have people necessarily talking. It's just as far as, it can't be controlled or regulated necessarily, other than you may want to, if it's someone you're calling to say, but please don't discuss your testimony with anyone else. I mean, that kind of thing can be done. But as far as actually controlling it.
Yeah, after someone's witness proof, and then they know kind of the questions and everything that are going to be asked, then I guess, there's no way to monitor them. But I feel like in ICTR case, especially some stuff that's come up is exactly that. People talking to other people that are witnesses, and then...
You mean after they finish their testimony, they go home and then discuss what they talked about in trial, or?
It seems like then in the judgments, there's stuff regarding that. Well, this witness, it seems like sometimes it impacts what people could say if they're coming in a later position than someone that came earlier.
Yeah, it definitely impacts. The timing, it depends if you're talking, of course, during the testimony, they cannot talk to anyone. They can't talk to even the party. Once they've started the oath, they can't talk to anybody about their testimony, not even the party calling them. You're done talking to anybody until you're finished. But what happens after you're finished? I don't usually see an instruction. They usually say, thank you for your testimony. We'll see you. It's very nice you came here. There's not usually an instruction that says don't go tell anybody about what you talked about here, because they can't, because these are public proceedings generally. They're meant to be. So everybody could have been even watching.
Right.
The only way to know or regulate, I guess, if it were, is if you're in that proofing session, you may want to ask, have you followed proceedings? You might want to know what could come out, because that will come out on cross often.
Right.
You might want to know that information in advance, or if you have a suspicion. I mean, it wouldn't be a general thing, but if you have a suspicion that they've been talking with somebody or something, that might be something you need to know. I mean, because you don't want to put somebody up there who's going to be telling somebody else's story. That's not okay. You have a duty to make sure that that's not happening. But how do you know? You don't know. I mean, this is just everyday life. That's the problem. Unless you have a strong suspicion, I don't think people are really asking that. Usually it's coming out on cross then, where they found out because they heard from somebody else. And they say, well, did you talk with somebody about this? Well, maybe if they tell the truth, yeah, we talked with Uncle Fred, I mean, maybe, but maybe, also maybe, they're like, well, not about this, but we talk about, farming, whatever. I don't know, so you can't, I don't think you can regulate it other than informing witnesses of how this should work and what the goal is of these proceedings. But you can't watch people all the time. So it should work itself out through litigation, I think, as far as determining credibility and reliability of the witnesses who come. And that's your job in appeals then, usually. On the other side, the flip side of all of this, we've been talking about proofing and what you can and can't do. Okay, now you're the other side. You could be getting a proofing note as the prosecutor, as the defense. I only know it as the defense, so I'm going to speak from that perspective. proofing notes often came very late at night in the cases I was on, and these were all limited to the cases I was on. They would come 11 at night, maybe in the morning, the witness said this. Sometimes it's innocuous. Sometimes it means nothing. At line 3, they said it was 3 people there who they didn't know, but it should say, actually, it's 4 people. Does that matter to your case? I don't know. It might not. That's where you have to have a good grasp of your case and understand what that actually means. If you get a proofing note that's, for example, I have some printed here we can go through, that is pages and pages and pages long, and you get this at midnight, and they're starting in the morning, whoa. Because you have a lot to go through. It's like a new statement in some ways, but it's not a statement. That's how we're going to treat them. So that's even more interesting. The manual of the ICTY, not the ADC one, but the ICTY one actually says that although it's not mandatory to have proofing sessions tape recorded, the proofing party can provide the notes of the proofing session to the other party consistently with the requirements of fair and impartial proceedings. This is just a can. This is a suggestion. You do that. I think in practice what happened is it really got rolling at some point in the life of the tribunals where they were doing this as a routine basis. Every time they talked to them, they made a note of any changes, simply because it made for more effective proceedings. It did, however, create tremendous problems of notice. What is the statement? Especially if somebody has 5 statements. This is not unheard of. Somebody could have 5 different statements, and you're already trying to figure out how they match up. And you've done all of your legwork, and you've been working for weeks and preparing your cross-exam for this, and then the night before you get this. And you think, and then you look and you see, how does each of these things, at paragraph this, at paragraph 41, the last sentence reads this, it should say this. Okay, you have to look and see, but does it matter? That's the real thing. Is there any harm? Is there actual prejudice to the notice? Not every fact of a statement matters to your case. That's the point of having them there for examination. That's why you don't just put the statements in, for one reason. You don't want all of that stuff in. That's not necessary. They may have been talking for pages and pages. They may have talked about different subjects. It might have been in the context of another trial that they gave another statement. So it's not even about any incident you're dealing with. So you just have to see, maybe it matters, maybe it doesn't. And that's where, again, you really have to know your case and know how this factors into the larger picture. Did you have a...
Do you treat the notes now, just from defense perspective, on a good faith based on the ethics and the rules that they should follow to proofread the witness, or you might consider something which is in a bad faith? Let me put it that way.
I think you have to take it all, that it's all coming in good faith, and everyone's acting and doing their job properly from the code of, under a code of ethics. And at the SEC, there's now a code of conduct for the prosecutors as well. I think you have to have that good faith basis. Otherwise, nothing's going to work. And plus, if you're making some sort of allegation of coaching or improper action, you better have something to back it up. Because otherwise, you're dragging yourself through the mud in that, because you can't just sling around allegations. It's very serious, especially when you're dealing with people who are held to a very high ethical standard by code of conduct, or should be. So I think, yeah, generally most people are proceeding on a good faith basis. At least you may have suspicions. You may say, somebody said something to them and now that's why they're saying this. But I don't think it's anything you're going to go further with unless you had something very concrete.
And you might expose this in the cross-examination.
Exactly. Yeah, how you deal with it. What happens next? What happens when you have significant change? I have here. You can ask for a delay. If it's a big long proofing note and you think, oh my gosh, I have an hour to deal with this because I thought I could sleep. I was all prepared. I'd been working for days. I get up at 8 a.m. and it came at 10 p.m. and I had gone to bed early. Oops, I shouldn't have slept. But instead should have been up waiting to see. But actually, if it's something that then is a 10-page proofing note that has all sorts of different things in it, you could probably go to the judge that morning and say, you know, Your Honor, we received this proofing note. There are a substantial amount of changes in this. Can we postpone the cross-examination? Give us time to review this. In some cases, you might be asking to recall the witness, because this is going to take me weeks to go over this. I need to go do an investigation in the field. I have to talk again to this witness. of mine. I need to talk to my expert. I need to talk to, do whatever in further investigations based on the new thing. If it's really radical, you might be having a stay. You might be asking for a permanent stay of proceedings if it's that significant. If it's something really, like, all of a sudden, it's your guy who's there and he was never there before. You might be asking for something, or it wasn't your guy. Sorry, the opposite. It wasn't your guy. I know before I put the guy in the dock in my statement as the one who was murdering people, but he didn't murder anybody, actually. He's a really good guy. And I know this because I was in jail with him at the time this is happening. Okay. Well, that would be pretty great, actually, because being in jail is about the best alibi you can have. It's usually pretty easy to check out. And he's a great guy, and he's not murdered. I mean, in that case, that is radically changing whatever defense strategy you had of your case that you were trying to deal with. So it really depends on what's in there. I mean, that doesn't happen, actually, but if it did, you might actually have to see it. If it's their star witness who's now recanting, that does happen. Sometimes cases fall apart. You never know. If there wasn't necessarily a proper investigation done in advance, or if something happens, it could happen. So keep on it. So I shouldn't say it doesn't happen. It usually doesn't happen in a proofing note. Usually there's some indication far earlier than that.
Have you ever had to ask for a stay, like for a long one?
Not a long one. It was usually in the cases we had. It's all so old and fuzzy now, but I think nothing was more than we did ask to recall a witness. At one point, actually just asked them to come back at another time because it was something that was going to take longer than having them sit around in The Hague. This is something that they had to deal with. Otherwise, generally like a day, specifically we weren't asking for time usually. We would say, we need time to review this. The judges would then talk and then they say, all right, we'll give you till tomorrow. Or we'll give you until, well, it's Friday, we'll give you until Monday. We'll just adjourn now. You see, that actually happens, I wouldn't say routinely, but it does happen with enough frequency that you can find it in the record that they say, okay, fine, we need to investigate this. And it might not be a proofing note, it might be a new piece of evidence that's come up or something like that. I wouldn't say routinely, but common enough, let's say, that they'll grant that and just say, we'll adjourn for today and we'll come back to this tomorrow. When you get significant changes, or when you get changes, you have to look at what is going to be the proper remedy. How do you deal with this? You have to know, how does it affect your case? How does it affect the cross-examination you've already prepared? Does it or doesn't it? Maybe it's on something that's super minor. Maybe it's on something that actually is going to change a whole line of questioning. That's where you might be asking for some time, because that's not effective use of the courtroom time if you're sort of, trying to make it up as you go. Your Honor, I had a line of questioning that was on this topic, and now this fact changes it. Can we have a small adjournment so that I can, rework my cross-examination in light of this new information provided? It might be something that you can just pick up, though. It might be something where you're like, oh, okay, well, the trucks were blue, but now they're green. Well, this is important because actually that's a different set of forces, maybe. But maybe it's something you're like, you have enough time. Maybe you were up. It was 10 o'clock and now you've stayed up all night and you actually went through it. You might still complain, I don't know, but you might be able to say, but we can go forward. We got this very late, Your Honor, but we're prepared to go forward. We can do this. In which case you would have just redrafted that section of your notes, or maybe, and then question them. You might want to, this is where a lot of it works itself out on cross-examination. I mean, this is going to credibility a lot of times then. Well, I shouldn't say that. You might question his credibility. It might be something that was just simply a translation error or something, but it could be a credibility thing. You said this was green, and now it's blue. You said it was the first, now it's the second. And if it's a bunch of changes that are now radically different, you may be trying to test the credibility of this witness. Maybe not even that they're being purposely evasive, but they just aren't reliable. They simply don't remember enough to be a reliable witness in this instance. Again, it might not be malice. It might simply be, it's been a long time, they don't remember. This cannot be used to convict this person because it's simply not reliable enough, actually. So please take that into consideration when you weigh their testimony later. So you may be just poking those holes that in your final arguments you'll say they weren't credible. Their proofing note shows that they changed 20 different things. They were all over the place. And they said 3 different things in their statement before. They're just not reliable. They don't know, unfortunately. So please don't rely on them. And do you enter it into evidence? This is where I had said this earlier in that earlier case in 2001. Judge May said these proofing notes, they're certainly not exhibits. They're not in lieu of witness statements, but they are for the assistance of all in the trial. Well, that's true, but what if it's significant? Sometimes they do come into evidence, actually. If it's something that you're questioning them a lot on, it's something you want the judges to have outside of the record. If it's something that you're trying to impeach their credibility, that's something where you really want to look then at, maybe you need to admit this. Maybe the judges aren't going to accept it. Maybe they've said, we're not taking proofing notes, we don't want those, just question them about whatever's going on. But maybe they do accept them, or maybe you really want it and you want to try. Maybe you're going to tender that. You just have to know exactly, again, what's going on in your courtroom. So when you get that proofing note, first thing, does it affect your case? If it doesn't, just ignore it. I mean, really, you're going to get these with a lot of different witnesses. If it doesn't affect your case, maybe don't make a fuss. You have to pick your battles in these cases, and there's a lot of battles. So maybe it's not, you know, you don't have to say, oh, I got this at 2 a.m. If it's a part of a practice, but if you got, you know, then you're really going to want to make sure that you put that on the record every time. But if you got it at 2 a.m., it only happened once. They're usually giving them to you a week in advance. And this one says, actually, my birthday is the 13th of August, not the 12th. Same year. Who cares? That does not matter. You know, don't pick your battles. You don't necessarily need to go in screaming, you know, we got this an hour before, simply because it was late. Unless this is becoming part of a practice, then that's where you really want to make sure that you have that adequate time and facilities. That's where, check it against your cross-examination, those questions you're going to ask, check it against statements, see if there's any other evidence. Does it require significant investigations, following up, and what about the timing or your prejudice, as I just said? Those are the considerations you really want to make when you get that proofing note. And always have an eye on those rights of the accused. Adequate time, adequate notice, facilities to prepare and try their case. You have to know the case against you when it starts. It cannot evolve as you go. This is in the jurisprudence of all of these courts. The prosecution can't shape the case as they go. They have to know the case when they start trial. And so it's very important that you know those rights. It's 67 at the ICC. Here it's 21. You'll find it in articles. It's 20, I believe 20 at the ICTR. Just know the basic rights. You should know them like the back of your hand as a defense attorney anyway. You should be able to pull those numbers out of everywhere, because that's what your reasoning is. That's where the prejudice comes from. You didn't know the case against, he didn't know the case against him or her. Therefore, they couldn't adequately do anything about it. So know those inside and out, as far as that's what you're going to be hinging any objections on. And what do they actually look like? I just wanted to quickly, since there are some in evidence, as I said, look at some of these. What do they look like if you've never seen one? Well, this is actually an example of a supplemental information sheet. You can find these if you go into the JDB. I don't have any, I've not seen any at the ICC. We don't have the same access to exhibits just generally yet, so I didn't manage to find any there as an example. They might exist, I'm just not sure. I know at the ICTY, if you go in the JDB, you can search proofing notes, you can find proofing notes, but what are they called? This one's called a supplemental information sheet. This is, again, where there are no protocols, there's no guidelines, so things are different. You don't necessarily know exactly what you're looking for. This one's a supplemental information sheet, some of the ones I found. This one is called a proofing note. This one is an information report. And these were actually, I wasn't even looking at a lot. This is just the first 5 I pulled. They all have, you can see, a different format. They have a different style. They have a different title. And they all have something, because there was no guideline on how to do this. It was simply the party deciding.
Different cases?
Mm-hmm. Yeah, usually within a case they will be the same. They pick a style. But it's generally up to whoever's doing this, or that trial team, as to how they want to convey this information. The importance is they convey the information. It's not necessarily about the format. There's no set template necessarily. And some of these come from the defense. Some of these, here's one. This looks like a letter. Actually, this was from a defense team. Dear counsel. It's written like a letter to all the other teams here, actually, because this was in a multiple accused case, and to the prosecution. You can get a lot of different things in format at the ICTY and ICTR, the ad hocs generally. I don't know if there's a set format at the STL, maybe you know, for proving note. There's usually a set format for everything there, so yes, yes, I would imagine that there is. And now you have, as far as this protocol goes at the ICC, I've not seen any template, so to speak. I don't know, maybe there's template. But they do, of course, in that protocol give certain information that you have to have, the location, who's there, and how long did it take. in that protocol, if that's the protocol that applies. Because these, not necessarily. If you're looking at this one, you have, it contains additional information provided to the council on this date, so you have the date. Present were these 2 people. So you have the people and you have the date, but you don't have the location. We don't know where they were. Could be anywhere. But they weren't required to provide that, and it just wasn't important to them, and no one had said anything. Or maybe they did say something, but it wasn't. You can see, and this one's a pretty good example, because you can see, actually, if we, I don't know if I want to zoom in here. Typically, you'll have, in paragraph this, the sentence reads that, you'll have a lot of that. You'll have, you know, this is, look to this point, and this is the specific change. Not necessarily generally, but sometimes they are general changes. And here you can see the sentence number and the revision. There you go. As far as the actual changes, this one, I think, if we're looking down at 6 here, 4th sentence reads, I want to say the reports contained in general information, blah, 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 blah. It should read, but they're talking about losses versus needs. That's a bit of a different word. Losses, logistical losses versus logistical needs. That's a bit different. Probably happened in some sort of interpretation as far as, and then somebody else recording it and something read back and some word got changed, but that maybe means something, maybe it doesn't, maybe it means nothing to your case. But it is a significant change in a word as to what they're talking about there. Maybe that meant absolutely nothing, I don't know. But that's where you have to know your whole case and how that all fits in there. But it is a different word. I think I have, this one is quite extensive, and this is from Hardina, I believe. Like I said, Hardina had a lot of issues that went on as far as the practice of proofing witnesses, and the process that was being used, and issues that came up in litigation. So this one is 5 pages long, and it tells like a story. It's quite wonderful, actually. I don't know how I can...
Is it the defense?
No, well, the defense didn't have any witnesses. So, no proofing.
Oh yeah.
So
and then the disc came.
This is the proofing note of this person. These are all in the JDB. It says room 326. Oopsie. Room 326. We know exactly where they were. We have that. 23 March. We know the date. We know who's present. We have all of those things. We have specifics. The witness arrived at 2:15. Because there were issues, this is very, very detailed. And I don't know if that's related or not as far as timing goes and where this fits into the whole grand scheme of that case. You'd have to ask people on that case. But as far as this goes, this is one of the most specific ones I've ever seen. And interesting, it reads like prose. They took them down to room 326 and the interpreter arrived. And then we were talking about how they explain the process, who he is. Okay, he's telling them what they're going to do, and this is sort of where you're doing a bit of a familiarization of the proofing process itself, actually. They're going to get his statements. Is that all right? And in the meantime, they're asking the interpreter if she can just maybe interpret back and forth, to which the interpreter, in the meantime, said she wasn't licensed, permitted, approved, allowed to do interviews, and was only a translator. So that's okay. Anyway, in the meantime, they go to get a recording device and ask the witness if he wanted coffee. Black, no sugar. Espresso, okay. He went in search of coffee and a recording device. You know, it goes on, and it reads more like a story. I actually was very engrossed in this. It's very interesting. It's not typically what I've seen in proofing notes. Typically, I've seen the one that we saw before. In paragraph this happened, in paragraph this. And they're a little bit more specific. But this one, and then you can see, here's where it actually starts. That's all a prelude. Here's where the proofing session actually starts. And then in the proofing session, sequence of events in first statement is not quite right. Ooh, well, we better get this right. So this is where you're almost getting into another statement at this point because it's so long. And if they start off with, well, the sequence isn't right, okay, well, we have to go back to the beginning. Again, like I said, and there's notes here. I don't know if this is a note to themselves or how this came in. As I said, procedure, I'm not entirely sure how that goes. But this one is quite unique as far as process of what I've seen, as far as the sort of narrative of black, no sugar, espresso, okay. I mean, that's very, very specific. I don't know if coffee was an issue with this person, but I've not seen that. And as I said, then here's the letter again, you have who's there. Information report, this is one I'm very familiar with, this type actually, and where you'll have, again, here you would have ICTY, I'm sorry, I couldn't find this one again, I don't know why I didn't write down the number of exhibit number. But this was in the Dragomir Milosevic case. And this is a format that actually I saw very much of. I was not on that case, but it was used by probably whoever was doing these in the same vein. Information report, submitter, there's his name, the date, and the subject. Information for proofing of this person. Now, the first line says, the witness says he has never seen General Milosevic nor General Galic, at least not during the war in Bosnia. Okay. I don't know what his actual statement said, but that's pretty broad. If he had at all said before that he had seen them, that's going to be significant, that now he hasn't. Maybe he wasn't asked, and maybe it's something he just brought and said, oh wait, this is a trial of him. I never saw them during the war. It could be just that, and maybe it means nothing. It could mean whatever it means in the context of the case. That's why reading this alone, you don't know what that actually means. You have to know your case and figure out where that fits in with all the other evidence. This one actually includes a lot of opinions. So that might be somebody who's just coming and saying, I'm going to testify, and so I want them to know all of these things. You know, witnesses are human beings, and so they have different characters and personalities, and sometimes they just want to chat, or they want to tell you everything they know about things. Or maybe they want to hold things back. You know, it's as different as many people you can meet as far as what you're going to have in a proofing session. So just so you had an idea of what these things look like, here's a supplemental information sheet again. Has the title, date, who's there. It's a little bit more formal, but upon reading his statement, he says he pointed out he would like to correct certain passages. This is pretty standard, that sort of language. The witness has read this, he wants to correct this, and then it goes as to what they're going to correct. Some of it might be significant, some of it might not be. But there you have it. As far as, yeah, we're pretty close. As far as it goes, what did they actually look like? You have that there, but again, I just want to finalize with a note of, know your intent as far as what you're doing there to not influence them, to make sure in recording as well. It's not just in your speaking with them, but when you're recording things, don't, try to paraphrase. Get as much of it as exactly what they said as possible, simply because, you don't want to be paraphrasing in a way that's subjective. We all interpret things differently, so the less interpretation, the better on that, especially when you're correcting something that may already be not quite accurate. There's some good statements about that in the jurisprudence as far as preparing the witness to give the witness's testimony at trial and not the testimony that the attorney has placed in the witness's mouth. That's a good way to look at it. And it's about how to testify, is the maxim, not what to testify. Have a plan for it, but prepare for anything. The things that might come up, you might see a witness who has additional information. He or she, I'll just say he, but might bring documents with them. They might bring some pictures, whatever. They might bring something with them. You have to figure out, sorry? Diary. Oh, whole diaries, yeah. You have to figure out what do you do with that then when they bring this. The witness may recant. The witness may actually change their story in a way that's significant to you. It's not recanting, but it's just added a detail of all of a sudden, maybe the defendant, you're the prosecutor and the defendant's now the greatest person on earth. You didn't see that coming. Oh, he still did these things, but now, that's going to come out. And you have to sort of put this all into a context. And what about your co-interviewer, if you have that other person there? What if they make a mistake? This is something that comes up. What if they start influencing? You have to make sure also, because you're a part of that process, that everybody is doing the right thing. So have a plan when you go in and make sure everyone's on the same page. Because you don't want to be doing, you've thought this through and you're great, you're going to do this perfectly, you're not going to influence or do anything wrong. And then all of a sudden maybe your co-interviewer or whoever's there is jumping in. But the car was red, right? You might want to actually even have a timeout and say, we have to dial this back, we cannot be doing that. It's something you have to work out with them. Maybe you have a relationship with them, maybe you don't have a relationship, maybe you don't know them, maybe they work in a different team but they've just been pulled into this one. It depends on your working style. Who knows? So you have to think about those other peripheral things too, to plan out and know what you're doing when you go in so that you don't fall into any of these pitfalls, because this is how wide the area is. So that is what I have, if anyone has any questions as far as sort of how we got here, the who, what, when, where, why, and how of what we're doing in these courts when we're talking about witness proofing, witness preparation, and witness familiarization. As I said, the first two, pretty much the same thing. It's just the parameters of your specific court and chamber as to what you're doing. Are there any questions?
Is there any impetus to make any of this stuff standardized, or just keep it? I mean, I know the tribunal then close eventually, like kind of soon, but is there? I mean, it just. Do you think there'd be any benefit from standardizing something like that?
Well, I honestly think the protocol, I mean, for whatever degree, you know, you want to change it, maybe. I think that the protocol is a good way to go with that. So there's some idea of what we mean when we say, when we talked this morning, you said, what do you mean, can you define witness proofing? And some of you could, but I think a lot of you could, but you didn't raise your hand maybe because there's a lot of the gray area and you can't necessarily define it. And I think that this witness preparation protocol does start the discussions as to the who, what, when, where, why. And I think it's a good basis for standardizing and then allows the different cases to amend it as is right for their case. I think that that's actually, while I'm usually just very fearful of protocols, the word alone freaks me out, but protocols is so serious. But I think that that's actually a good, this feels more like a guidance. I mean, it does have musts and shall nots, and it is a protocol, but it's guidance. It's a good guidance, and honestly, I think it is the later stages of the ICTR, well, you know, mixed. I wouldn't be surprised if someone would try to then introduce this in a case if it became relevant. I mean, the stage of the cases, it maybe doesn't make any sense, but if the trials were ongoing, again, like we saw Oidnich taking from the Lubanga and filing and saying, now we're not going to do this, I wouldn't be surprised if you'd say, hey, look, they use this, can we have something like this if we're going to be doing this, or maybe we don't do it, or you know, they're now allowing it, but they keep it here if they agree with it, or we think they should do this, but not recording or not whatever in line with ours. So I think that a lot of it is, it's good just to even have those general principles of why are we doing this, you know, what is the purpose, so it's not this whole grand scale of things. So to me, this is somewhat going that direction, to try to get people together.
According to your experience, I would like to ask this because you did mention a case where no witnesses were proved in ICC, and the cases where here it's part of our practice and exercise, proving witnesses. Do you think justice is somehow, they will reach the same, or there is some kind of, is the objective will be met if the witness has been proved or not? Do you think the outcome, according to your experience, they will have the same outcome or it will be different?
So you're asking if I believe witness proofing should happen? The question, the ultimate question, should we have witness proofing?
Yeah, well, I have an opinion. Personally, if you want to ask me, I would say no.
No.
The person has made a statement, and he will be cross-examined, re-examined, based on what he provided. And this will give more authenticity. Like, spontaneous is always what you always get from someone. But and that's why I'm asking, according to your experience, and knowing a little bit about the ICC, I'm not aware of that case. But do you think they will both reach by the end the same verdict?
It's so hard to say. I'm not going to try to slide out of this, but it is so hard to say just given the differences in the systems, that especially given that when we're talking about the Lubanga trial, that was the Tadic. It was the first trial, and so there's a lot going on there actually that they're trying to work out as it's the first case. You know, it's the Akies, it's the first case, and it's always, you're going to have a lot of different things that are going to influence. It's hard to pick one thing that's influencing or not. And it wasn't just actually, in my mind, I wouldn't say any of the cases had no proofing, because we had those exceptions every now and again if something came up. So maybe one witness was proved when there was that late disclosure, or experts were proved. So I wouldn't say there's been a case where nobody was proved necessarily. But as far as the whole picture of it, and now looking to the cases that are going to be starting in the next year, all of them are contemplating proofing right now. There's no case that has said we're prohibiting this. It feels like they're all generally going towards it. Some, like I said earlier, defense teams have said, no, thank you, we don't want that, we don't need it here. Some have said that's fine. It works out because, you know, we're going to proof witnesses too. It works for both sides. And I think the trend, at least right now, is going towards it'll be proofing, though with a protocol. So I don't know what effect that will have as far as what testimony you get as well. My personal opinion on proofing, I think that's the thing, and I think I'm glad that you said that you don't think it should happen. I actually like that there are different points of view on this because I can see both. I do think that the spontaneity is good, especially if you really want to test that evidence. But there's so much going on in these cases, and you know, you have a war of 4 years, let's say, that they're talking about. There is a need sometimes, if you haven't talked to that witness in 6 years, to meet with them to really get this reined in. That, of course, though, can happen at an earlier stage, and this might be more my opinion lies in the timing of it. Doing it right before they testify might not be the most appropriate time to be talking about their testimony. If possible, I tend to agree, it would be fine if you're doing it in the context of sort of a further investigation at the pretrial stage to make sure that the case that you're going forward with is the case that you have and everyone has noticed, and this is what we're going to talk about. The night before, 2 nights before, 3 nights before isn't the time to be finding out what the witness is actually going to say on the stand. And that's where also, or influencing it, even indirectly. I think that's where, no, you do need to allow that spontaneity. They reviewed this a year ago. They know what this is about. They've received the familiarization process, so they understand what's going to happen here. And then that allows some spontaneity as far as they're not ready, they don't know every single question and are going to answer that way. So I can see the timing is a critical factor. That's, to me, it's what it is. A lot of things go with the timing, and this is one of those things where maybe it's the timing that's the real issue. Or maybe not. I don't know. I can see all sides of that. That's why, like I said, I'm really glad that you say you don't find it, because I'm sure there are people. Is anyone willing to put up a hand and say they believe in it, that this should happen?
And one of the cases when you do need to refresh the memory of the witness, in my opinion, maybe an impartial person or from a representative from the victim witness section who knows the ethics and the rules on how to proceed with proofreadings, because it needs to be, if there is no code, if there is no limitations, because you did mention at some point they prohibit, but then on the other side they open it, and it's like, okay, well, where do we stand here?
Yeah.
Or in that case, maybe a representative from the victim and witness bench who is an impartial section to be monitoring to make sure that the transparency is being exercised in that sense.
Yeah, I don't know. I get a little. When you say monitoring, I don't know. I think that's some sort of defense something in here. I'm like, oh, I don't know about that.
I don't know if the parties would.
And that's. I think that's.
You would end up having a smart bench versus a smarter bench on behalf of justice, maybe.
Well, I think that's what, this is what the video recording is designed to sort of do, be that check, so everyone knows they're being recorded and then they know that they're going to act properly, they should be acting properly, but it's also not something that then is going to be the same as a monitoring where somebody's always watching. It's something where the video exists, and if, I believe it's a good cause or something, I can't remember the standard that applies, that you think something has happened, you can ask for disclosure of that to the chamber, and the chamber can then review it and see if that's something that needs to be disclosed. And I think that is a good stopgap measure to make sure that there's some sort of compliance ongoing. Exactly. Between the protocol and the recording, yeah, okay. But I think that you have to be very careful. I mean, as far as recording it and just handing it out, and giving it over, again, I really don't like how that would affect the process. I think that it's something that it should be quite exceptional if it's recorded to hand it over. They really have to have a good basis to be seeing this session. They have to have a really good belief that something shady is going on. Otherwise, I think there should be the freedom to actually deal with your own witnesses in this way. Again, that's personal opinions here. I'm not speaking on behalf of anyone. I don't know, but as Isabel said over here, yeah, you're in favor of witness proofing generally.
Yeah.
So you'll find who's willing to say, I don't know where everyone else's opinions lie, and I mean, I don't want to put anyone on the spot, but it's nice that there are different views, I think, to discuss this, because there's so many, the thing is, it's hard to really put it in one box. Yes, or no, simply because it really depends on what's happening, and it depends on what you're dealing with. How long ago were people spoken to? Who are we speaking to? You know, what's involved here? There's a lot of different factors that play in.
I think you also mentioned at the beginning of the lecture how important it was to let witnesses know what their situation is within the whole spectrum of the case and how to also protect themselves. And I think that without witness proving, sometimes important information can be buried among unnecessary facts per se. And if you can at least guide the witness, not guide per se as in what to say, but tell them, well, we're judging these people based on these counts, therefore this is what's relevant, and then this is what you should really look into, and then this is how you should, yes, explain your narrative as you feel the most comfortable, but keep in mind the fact that this is what we're trying someone for, and then these are the relevant facts that we want you to discuss, not just go into some sort of monologue or soliloquy.
Yeah, and I think that's a good point. I mean, especially I think dates, especially since these are, usually very specific dates. I mean, the SDL, you have a very specific finite period of time that you're dealing with, in the context of a lot of incidents that go on. So of course you want to focus on this date and let people know that that's what's relevant. And I think it's interesting hearing both of your comments because I think you might say then, well, why can't the neutral party just say, look, here's what the case is about. Maybe I'm putting words in your mouth, but here's what the case is about, so focus your testimony on that area. But I would agree, because at first I was thinking, yeah, maybe a VWUS section could do this. But wait, then you're getting into what actually does it mean to the context of the case. If you're just talking about the date, that's one thing. But as far as what else is involved, or maybe we're talking about a swath of 2 years, that's a different situation. And that's where the party who knows the case and they know the reason they're calling that person, they're the ones who are going to have the best information there as far as how to limit this and keep this under control so you're not having, the witness talking ad nauseum about something that's not pertinent and wasting everybody's time.
Part of the council. Yeah.
It's there. It might be one of the necessary evils, as it were. Something that has to be done given the way that these proceedings are structured. They're unique. They're different. It's not the same as in a domestic jurisdiction, where you might have a different way of dealing with it. This is what we are, and therefore sometimes the things we do aren't necessarily making sense if you put them into another context. But I do think that it's good if we have a general understanding, everybody has the same understanding of what we're doing, why we're doing it at least. So it's not they think we're doing it to coach and we think we're doing it to this or whatever. That we all have a general idea and an agreed idea, and that's where then you have negotiations about protocols, so everyone has the same idea about what we're doing and everyone's doing the same thing. I think that's pretty important.
So are the currently here after was it Hardina that the videos? Do people do videos every single time?
No. The videos are not done here. There's specific instances, I think, where they've asked for people to be recorded. And there are certain periods of time, I can't really recall the whole thing, and that was specific to certain witnesses and cases. But as a general rule, no, there's still, as far as I know, somebody correct me if I'm wrong, at the ICTY and ICTR, there's still no protocol guideline, overarching one. There might be in specific cases they've said you're going to do this or you're going to do that. If you have a proofing note, do it before. But as a general sort of an overarching that's being used amongst different cases, I haven't seen that, but I can always be wrong.
I support witness proving. I think it's important, but I think having that, the annex, that protocol, or having that rule that there are the videos, not everyone has access to them. If you need them, they're there, but that people are doing that. I think that would be good because it's some way of at least having a record of it if you need to, And like you said, having a way of knowing. Going back to that, why are we doing this? All those things, I think that could be a real help in terms of guiding it and not letting it get kind of out of control.
I agree. It's nice if we're all on the same page about what's happening in the proceedings. So, always good. Were there other questions, or is it getting just too hot in here? It's, okay, so, it's 12:44. So, and if we're going to try to stay on time with 2, 4, 6, 8, 10, 11-ish people. Okay, so when we come back, we're going to try to do some group activities. So maybe if we can have people working in pairs, and then one group will be 3. Is that doable for everyone? There's 11 of us, yes? Yep. No one escaped, or that might come back. I mean, if they did, it was for good, right? Okay, so yeah, if you guys could somehow make pairs, and before you leave for lunch, come up and let me know, so I can tell you which witness you will be proofing when we return. Actually, from the booklet of wherever your information is, the packet that you have has some witness statements in it. That way, if I can tell you one person, then you can just read that one and focus on that, actually, so you don't have to read through everything. That is, you can use the whole record as far as whatever you need to do in proofing, but one statement you'll be focusing on, that will be the witness you're proofing. Because there's multiple in there, we're going to mix it up by everyone doing a different one.
Yep.
Seems to make sense. So, voila. So if one person could just come up and ask me, then I'll tell you who to look at. Does that make sense? Just basically read the one witness statement, and then actually if we can come back in an hour, is that enough?
Yeah.
An hour, then we'll get started.
I mean, it's not much to read.
No, yeah, they're pretty short. They're not long. And if you only have to do the one, then that will focus life. So, yeah. What was her name? Donna?
Ivana.
Ivana. Oh, okay. Can I?
You just need to take them later for us.
Yeah, go somewhere. Yeah, come, let's go.
Ivana.
Well, let's just go ask her.
Yeah,
Exactly. She said one person.
So we can do it. Okay, you have Dano. Franco Graj? Oh no, I don't. Oh no, thank you though. Actually, no, that's not. I was thinking that I came here, I was like, oh, but at least I had brought just in case something in my mind told me, oh yeah. No, I think we'll be done. Now we're the YouTube, so.
Yeah, I didn't want to say that.
Okay. Sorry, Franco Graj.
Yeah. You want me to do 3? Okay, I think everyone is like 2, so we can just go to the
You already have a group of 3, because there's a person alone.
Do you all have your groups?
Okay, so we can
Is there any group of 3 yet?
There's like a few groups of 3.
There's a few groups of 3. Well, it's fine.
Which witness do we...
Oren Wittich.
Okay, I think
His statement will be in there.
Yeah, it's in there, yeah. Okay.
Okay.
No, Dano Blasio.
Dano Blasio.
I think I read it the first time, I didn't really read it after, but yeah, we always so it's fine. Yeah.
Okay, so
we have orange.
It's further back these days. Yeah.
Yeah.
Oh, I looked at. Okay. I was like,
I know, I'm not.
Well, she's been here 3 years and then she put the case long after the 3.
And who's your? We'll just go in the front here. And which witness are you requesting of VWU?
Graduate.
Is that you?
I think so, but I can't.
Why is the camera pointing at me?
It's not actually pointing.
What are you doing?
So we actually do a role-playing thing, so I was going to be a witness.
Oh,
that's okay.
Yeah, that's fine
Okay.
too. Sorry. Yeah. No worries. Okay. Got it.
This is
One second. Okay, you guys, we're gonna start with this group. They have their own witness internally, so they're going to be doing it this way. Otherwise, these people are all your witnesses. Otherwise, so we can begin.
This witness proofing took place on 6th of June 2015 in The Hague at 13 hours, 100 hours, with the presence of the witness and myself representing the OTP bench and a translator. I would like to remind the witness of the purpose of conducting such a proof. I have to, he has or she has the obligation to tell the truth, explain the purpose of the preparation of the session, which is eventually discussing the statement, the written statement that has been submitted previously on the 8th, statement, the way it seems now. And a specific incident that happened on the 8th of May, 4th of February 1995, between 1500 and 1600 hours. The following questions, if the witness eventually read his statement, do you I would like to ask you some clarifications because some things may not be very clear, and this consists about what was eventually your occupation during that period.
It wasn't a formal occupation, but I guarded my village from looting and pillaging, but I was not a formal member of the VAH.
So you're not a professional military service
No.
person. Okay. I have here some questions I would like to ask about. When you mention from the hills we could follow them by watching the smoke columns, were you physically watching them? You were tracking them, or you were just looking from a physical, like stable place and then looking over?
We were not physically tracking them. We could look over and see them.
I would like to ask you here about, can you elaborate about people who fled Verdun and ran into the forest? Were there the full, the community that ran, and can you contest that no one eventually stayed in the village? Can you elaborate on that, please? Here, from Verdun joined them or ran into the forest?
To my knowledge, there were no people left, but that's just to my knowledge.
Okay. My last question is about, you were shown a photo board lineup containing 8 pictures. Were the pictures provided to you by our office? Do you still have any recollections? Can you confirm about the second picture? About who is the man who was giving all the orders? In the third section here.
Yeah, the second picture that I saw, he was the man giving all the orders.
Yeah.
The defendant, and the fourth picture, I don't know. I think I've seen him before, but I can't be sure.
You still can't be sure.
I still can't be
sure. Do you have anything you would like to add pursuant to your statement before going into cross-examination?
No.
You don't have any changes, anything, any recollection of whatsoever?
No, no additional recollection.
Okay, thank you.
I think we'll probably, as usual, thank you very much, and thank you for going first, save comments until the end so as to not, give anyone else ideas as far as conducting theirs. So we'll just save that towards the end. If you have some notes or make some notes, because we'll try to make a proofing note from this, actually, based on what you said at the end of this, I'll give you a little bit of time to do that, hopefully. So if you can do it while you were only 2 there, this is why it's better, I think, if you have the 2, then you can, one can take notes while the other one's questioning, and vice versa. Yes.
It was small preparation.
Exactly.
I had to ask something, but taking into consideration, taking into account that I'm not leading the witness, that was my primary objective.
That is a very good objective to have.
To be as transparent.
Yeah. Okay, the next set, you two, okay. And you're both the attorneys. Who was your witness?
Oban Widget.
Oban?
Oban?
Or you sit on this? Or do you want us to sit
However you
like
want it.
this?
However you want it. You're in charge.
Okay.
Thank you for coming here today. I am Yasmin Peter, and this is my colleague Isabel Martineau. We are meeting here today on the 6th of June, 2015 at 2:30 in the ICTY meeting room for a witness preparation session. We will review the statement, topics, exhibits, and familiarization. I would like to remind you, as a witness or unwitted, you have an obligation to tell the truth. The purpose of witness preparation is to assist the witness who will be giving evidence during the proceedings, to help ensure that the witness gives relevant, accurate, and structured testimony, to help ensure the well-being of the witness, and for the calling party to assess and clarify the witness's evidence in order to facilitate focused, efficient, and effective questioning of the witness during the proceedings.
So we assume you already read your statement. Did
Yes.
you? Okay. Here is a copy of your statement. So we're going to go through the statement with you today. So if you have any comment, if you would like to add anything or change anything that is in there, please do. I propose that we go paragraph by paragraph. So what about the first paragraph that starts with the following statement? Is it entirely accurate?
Yes.
Okay. What about the second paragraph then? 22 years old at the time.
Yes.
Okay. So what about the third paragraph? Maybe we can go in detail by this paragraph. If you have anything to add, change, or...
Well, yes, I would like to change, it says dozens of tanks.
Yeah.
I would like to specify that there were actually 2 tanks that I witnessed entering the village, and they were greenish blue in color.
Okay. It's noted. Is there anything else that you would like to modify on that paragraph?
Yes.
Mm-hmm.
Give me a second.
You can take your time.
I believe it's in this paragraph where I stated that I have never touched a gun in my life. Or
That
is it
was,
in this paragraph?
that was in the paragraph, the preceding paragraph,
Oh, then
paragraph 2.
excuse me, I don't mean to be so troublesome. But
There's no
It's fine.
problem.
It's better to get it right if you just take your time.
But I would like to clarify that and say that at the time it escaped me that I own 3 rifles, but they're not for the purpose of being in the military, but because I have a very long family tradition of hunters. And because it's so familiar to me, I said this, meaning that I haven't touched a gun for military or combat purposes, however I am an avid hunter.
So do you own those rifles legally? You have
Yes.
some license?
Yes.
Would you be willing to provide us with this license?
I would have to look for it.
We'll keep in touch regarding that license then. Maybe we can continue. So paragraph 3, you said that you saw 2 tanks and that they were blue?
Greenish blue.
Greenish blue, sorry. I'll specify that. Is there any other things in that paragraph that are not accurate?
Are you referring to paragraph 2 or 3 at this moment? 3. Not that I can see.
Then I'm gonna ask you 2 simple questions. We would like to know from which place did you see the evidence?
As I mentioned, I could see everything because I was hid in a nearby hill close to the village.
Mm-hmm.
So.
And then can you specify how far you were on the hill to the site of the event?
Mm-hmm. There's what? How far?
How far? Maybe in meters or.
I would say. I usually speak in yards. So
In
this
yards,
doesn't-
yards is fine. Yeah.
Sure. But in terms of meters, perhaps 20.
Okay.
15 to 20, rough estimation. Was a little nervous, it's hard to tell.
Okay.
And the fourth paragraph is everything.
Well, now I can identify that the witness was actually Franco Grajic because I'll take that back. I take it back.
Okay.
Struck from the record. Can I do that?
It's done. We'll come back to that later. We're gonna show you the 8 pictures again, and then you can give us your opinion on that.
Let's be clear. What do you want to take back?
What I just said.
Okay.
Well, why don't we move to showing you right now those 8 pictures?
Of course.
So here are the 8 exhibits.
Yes.
So I would like you to look at them and tell us if you recognize any of those people.
No, I don't think I recognize any of them.
Okay. Thank you. So is there anything you would like to add, modify or change from your previous statement dated of the 28th January 1995?
Nothing more than I have mentioned.
Okay, good. Just to summarize how it's gonna go at the court, we're gonna ask you questions mostly on those, well, not mostly, only on those events that occurred on the 3rd of August 1994. After we do, the defense will cross-examine you, so they will ask you questions, mostly on the where you were at the moment to see the events and the distance.
I have a quick question. Would I be able to see the statements of other witnesses by any chance?
No, sorry.
But it might refresh my memory to see what other people are saying.
No, actually you should not be speaking to the other witnesses before the trial. And you know, what we wanna know from you is what you saw. So what you saw that day. We wanna have the truth, and we want the truth to get out.
But I do live in a small village, so I have a lot of friends who went through similar situations, and we've been talking since, you know, the 10 years that this happened.
Well, we just want to know what you saw, not what they saw. When they gave their testimony, we want to know what they saw.
And we completely understand that you've been talking about that. Please don't be influenced by those others. We just want your point of view. So then the defense will ask you questions, as I said. And tomorrow, the VW section will take you to the court and will show you where the judge will be sitting and how it's going to proceed. So you'll have a more, you know, specific view of how the courtroom will be ruled and how it's going to proceed.
I get very hungry. So
yeah.
Would I have lunch?
We can take some breaks and we can have lunch before. Yeah, I think everything will be fine. Don't be stressed. If you have any concerns, please come to us or VWU. And you know, after the defense asks you questions, the legal representative of victim may ask you questions. And just to tell you that the judge may intervene at any moment. And if there are some questions that we find that shouldn't be asked, we will object. So don't be worried. We're gonna be there for you at court.
And the judge is also will be taking care of maintaining the proper conduct.
Do you have any questions about the proceedings, maybe, or?
No, I just really wanted to know what Franco Savage said, but if I can't see it, it's okay.
Not for now, but you know, after all the proceedings are done.
And we also just want to remind you how important it is for you to speak slowly and concisely when you're in court, so that everyone can hear you, and so that there's enough time for the translators to be able to translate everything.
Okay. I'll try to remember that.
Do you have any other questions for us today, Mr. Orbitich?
No. Thank you.
No? Thank you. We'll see you at court then.
Thank you. Next group. Anyone here? Okay. Who was your witness?
Mr. Blakovich.
Sorry?
But we did our own witness for the...
Okay. Okay. No worries.
Is it your witness?
I think they have their own witness.
I think it's...
Was it you?
Like
the other one,
right?
maybe.
Never mind. The other one is so much cooler. Anyway.
Yeah. Okay. Hello, Mr. Blagovic. Thank you very much for coming here to testify in this case. We're very grateful that you took time to be here. And I would like to remind you that you have an obligation to tell the truth, and that we are here to hear what you have witnessed, and that the truth is of great importance to us. And the purpose of this preparation is here to assist you and to ensure that you give a relevant and structured testimony, and also to assist you in your well-being and to assess and clarify your evidence.
So we'd like to start by reviewing your statement that you made and seeing if there's anything that you would like to add to it or update.
Okay, let me check for a moment. I agree with what is already written on the statement. It's just that I see something small blank. To what I've previously said, when I talk about me and my friends being in the surrounding hills, I would like to specify that when we learned by co-villagers that the Army of the United Federation was coming to our village, we were so scared that we decided we should immediately leave the village and go to the forest and hide, to the hills and hide. But then we realized that we didn't have the necessary things with us, some money to finance ourselves on our way, and maybe some food in order to survive. So we took the risk and we decided to go back, hide in some bushes and try to reach my place, actually, so that we get some necessary things and then lead back to the hills. That's when it all started, and we saw the soldiers approaching the two men, and all the events happened after that. And
is there anything else you'd like to clarify?
Yes. In the second paragraph of my testimony, I see that I mentioned that the army set the houses and mosque ablaze and shot the livestock. Well, maybe I exaggerated a little bit. They didn't stock all livestock, it's just that it happened that we saw some animals being killed among other people.
Okay, thank you for clarifying that. Is there anything else you see that you would like to clarify or update?
No, I agree with the rest of what I have said in the past.
Okay, so when you are called into court, we will only be discussing the events that you documented in your statement from the 14th of July, 1996, based on the events of August 3rd, 1994. That's all that will be discussed. However, something that during the cross-examination that the defense may bring up is the fact that you did not recognize the man from taking the shots, but you recognized him as being present, and wondering how you made the distinction between the two.
I thought that it was clear from my statement, but what I meant here is that I could see a lot of faces of soldiers. I don't remember many of them. I remember, though, the two I already indicated. However, who took the shot is a different thing, because I saw somebody, but somebody stepped in front of him, so I wasn't sure who was the one pulling the trigger. So
Thank you for clarifying that.
So we just want to clarify to you that you may not be questioned in court on matters upon which investigators previously questioned you, but you don't have to worry about that, because both us and the judges will be there to make sure that the examination will be conducted in a just way. And I would like to ask you to confirm whether the registry has given you a tour of the courtroom and explained to you what the roles are of the various participants in the courtroom. Yes. So do you confirm that you understand the roles of those participants in the courtroom? Yes. Okay. And I also want to discuss with you that appropriate witness behavior is very important in court, and so it's very important that you speak slowly and concisely, and that you address the judges as Your Honor or Mr. President. And this is also because it may be a bit strange, but we would like to ask you to wait 5 seconds before answering a question, so that the interpreters have enough time to translate everything. And so do you have any further questions about anything that discussed?
Would I be able to read the testimony of my friend, Mr. Oran Vitic?
No, we can not allow you to read any previous testimonies.
Okay. Thank you very much for the explanation of the procedure. I will try to follow the guidelines.
Thank you.
Take your best to being a witness.
A professional witness. Who knows?
The shaky voice.
Yeah. We have 2 groups left. I don't know if either of you.
We don't have to.
It's kind of distracting when you guys are talking. And I know that you're trying to prepare, but I try to pay attention and then I keep hearing you guys talk.
You're last? Oh, they don't have to go in order. You can be now if you want.
I think that's not the issue.
Yeah. Oh, you want to be last?
No, I was just saying it's distracting.
Yeah, there's different. Yeah, she was saying the noise, but. Should we flip a coin? We have witnesses for both the groups actually here, so you don't have to worry about that. Yeah, I'm gonna flip a coin. Heads or tails. Flipping a coin doesn't work without heads or tails either. Okay. Who was your witness? Thank you. Oh, I think there's only one woman witness. Yeah. Is that you?
Yeah. I'm preparing coffee now. It'll be fine. Dana's just preparing a coffee for us in a bit. Thank you.
Is it already on?
Okay, you guys, we're gonna start. It's a small room, so try to stay quiet. And for the next 10 minutes.
Thank you for being here. Myself and we are both representing. We are both representing the defense team here. We would like to review some aspects of your prior statement regarding the moment when you were hiding in the cowshed with your sister. Would you like to review any of the paragraph of your statement?
I've been reviewing my statement, and rereading everything is really hurtful for me. My sister got beaten to death, and I've never seen her again. I can't walk anymore because I have difficulties hearing. So I've decided not to testify.
It's really very difficult for us, but we don't have, we cannot do anything, so we...
I'm willing, if you can use my statement, but I do have some problems about the dates because I can't confirm if they're really the dates which I said in my original statement because I was in shock at that time and I'm still, so I can't recollect everything.
Okay. Would you be able to say that the year is correct or not?
The year is correct, indeed. But I was going through my statement and I cannot say if my sister and I, when the bad people came, we were hiding in our house and I said it was the 3rd of August, but I cannot really tell. I only know it was beginning of the summer and it was really, really warm.
Okay. Could you tell us if you clarify if the people were 6 or 7 or you just don't remember?
I do remember there were 3 people beating us. But
okay.
One was really tall, so I think he was the commander.
You think? Could you tell us why the reasons?
They beat us?
No, to be the commander. Why you think that he is the commander?
He was standing in the middle of the 3 of them, and he was screaming a lot.
In your statement, I believe you made a difference between his uniform and the uniform of the other soldiers that were his subordinates, according to you. Could you elaborate a bit on the differentiation of the uniforms?
I can recall he had a special badge on his left side, and it was red. But again, I was in shock, so I kind of really know.
Do you see before soldiers with the same uniforms, or in the first time?
I was hiding in the house, and at that time we were hiding in the house.
Okay. And one more question. You said did they belong to the Federation Army? How do you know this?
Because my sister and I, we knew the Federation Army was really brutal, and since they were brutal to us, I assumed they were from the Federation Army.
Right. Also, towards the end of your statement, you acknowledged that you felt your memory of these events was affected. So, once again, you confirm that you're not entirely sure of
my
the accuracy of this statement.
Indeed. And that's why I do not want to testify, and I do not want to relive that experience.
Well, thank you very much for your time, and we're so sorry for the trouble.
Thank you.
Thank you.
Thank you very much. We have one more group then. I believe you're Milan.
Yes.
Markovic. I have your witness here.
No, please don't.
Sorry, this is unclear. No, because we had some hidden eggs, as you see here, as far as things that would come
no
up.
problem. Okay, you can be. So we can ask you the question.
Okay.
So like the introduction.
There was an identification.
He's a professional
problem.
witness.
Wrong tattoo.
Thank you for coming here. Thank you for your justification. You have the obligation to tell the truth. Our purpose is to assist you in order to clarify the evidence. Please try to be brief and just reply our questions. So,
okay. I need to know first, though, do I have protective measures? I asked for protective measures. It's very important.
Would you like that your identity would be held?
Yes, I think I've said that that I need to have my identity withheld for obvious reasons. I don't think I can testify unless I have my identity protected.
So, what is your name? Okay. What is your name?
Milan Markovic.
What is your occupation? What was your occupation?
I was a member of the Army
Under what commander?
Commander Artukovic.
Okay. When did you arrive to the village of Verdi?
3 August 1994. In fact, the other day I was looking through some old documents. I actually found the order for that operation, but it's at home.
Okay. Okay. So, what? How do you know about the crimes?
Which crimes?
The execution of the 2 terrorist guys.
Yeah, well, as you know from my second statement, I changed that. I was in the other room, and when Commander Artukovic went out with the other soldiers and the 2 youths, he told me and Captain Boban to go and prepare the men for departure, so we left at that point in time. But afterwards, I heard what had happened from my friends who were there.
So did you see the executions?
No.
Okay.
Did you remember the names of all those people who were with you?
Yeah, I mean, our commander, Boban, I actually brought some pictures that can help. I've got some pictures here of us that can help you identify us. There's Commander Artukovic, there's me, and there's Captain Boban.
Okay.
That was in Verde. I have some more pictures too. I don't know if they could be of assistance to you.
Okay.
You were how many people?
Well, we had a whole unit there. I don't know who was there at the time, but these are a lot of pictures of Commander Artukovic. He's a great man,
Yes.
a very strong pillar of the community, and he's really like a saint. He's been good for everyone. He's a positive man, and he's a great leader in the community. That's him, right there. That's him right there. That one's maybe not so important. That's the commander in Montenegro.
Okay. Fine. So, did you see what happened with the bodies then? Or?
Nope. I heard that they were there, but I had left with Captain Boban already, and we were telling the tanks to reposition.
So how do you know that these people have been killed?
That's what people were saying. That's what people were saying.
So it's not something that you have seen? Oh.
No, and I can't remember. They took 4 statements of me, and I can't remember. I was confused during the first one when they were asking me, and so that's why I clarified it when they showed me that the first statement said that I had seen it. I did not see it myself personally, no.
Okay, so I think it's fine, or?
I think it's fine.
Okay, thank you for your time.
Do you want to keep the pictures?
Yes.
I'll keep this one up.
I can give her my bed. Yes.
Thank you very much, everybody.
Pictures around.
There's just some strange things that can come up. Sometimes they find random things. Just give me a couple minutes. I think we can probably take a little break, but let's make it a working break again. I'm not very nice to let you just sort of have breaks, I guess. But maybe if we just take the next 20, 25 minutes, if you could just make a list of the things, just sort of your idea that you can present on what then you would do, if any proofing note, what kind of a proofing note would you do, what would be in that proofing note, or what disclosures would you make to the other side then, based on what happened in your conversation there. It's not much, obviously, it doesn't have to be formally written out or anything like that. Let's just go through and just jot them down, and then we'll just verbally, we can orally present what would you be passing along to the other side, what would your considerations be, just so we have an idea of what comes out of that then, of that session.
Just a question.
Yeah.
As in our case, doing this one certified, can we use the testimony to before or not? It's strange. Of course, there is no cross-examination. It's
Well, and that's what I think right now for this, the purposes of this, maybe talk about that. So those are some things that maybe come up. Maybe that's some avenue you're going to go with. Maybe you're going to approach the other side and ask them if that's something they'd be willing to take statement evidence on or something, given these considerations. This is what came up. Maybe that's in your proofing note. So maybe that's what we're looking at for the next part of this exercise. Just what considerations did you make from what happened there? How are you going to deal with this now? If you have somebody who says, I don't want to testify, you know, what other avenues do you have, and what are you going to be then telling the other side about it? So then when we can go back, when we come back, well, we'll be here, but whatever, after we're done with the coffee. If you have an idea, then we'll just go, one person from each team can just tell us from where you're at too. Just simply, you know, here's what our considerations were, and here's what we'd be disclosing to the other side, based on what happened in our mini proofing session. Is that clear enough? Okay, thanks. Try. I wanted to do another one. I had this great, grandiose ideas of a rainy day and all of us, everyone wanting to stick around. And we can, but actually then responding to it, because I think it's important to take whatever you do on one side and look at it from the other side. How would you deal with it if you're the other side? That's a good way to gauge if you're doing the right thing or not. And if you're going to get any problem, is it going to go through? Anticipate all those problems. So I was thinking to have, then after we did this exercise that we're going to do right now, then we could make objections, but that's just going to take us way too late in the day, and I'll be murdered here probably. So I think what we should do then is, as I said, we'll go around. You can give your considerations as far as what you would be disclosing, what would be in your proofing note. There's a drafted proofing note over here, actually. What you would be doing for the other side. After then, that team goes, each one. I'm going to give a couple of thoughts I had on that group, and then maybe whatever thoughts you had, and maybe if you're looking at it from the other party's side when they're giving their proofing note. Have there be the other side when they're speaking, and then maybe we can have some comments about what would happen if you received that proofing note. Does that make sense? Okay, excellent. All right, any takers to go first?
Can we turn on the AC?
There's no AC, I'm sorry.
That's why we're going faster.
Yes.
Okay.
We can go first.
Please.
So I used the title proofing note, even though there was some other non-variation. Proofing note of Oren Wittich. So the 6th of June, 2015, ICTY meeting room, 14:35 hours to 14:45 hours, and then present the witness Oren Wittich, the counsel for prosecution Yasmin Peer, and the other counsel for the prosecution Isabel Martineau. Dear counsel, we met with Oren Wittich on this day, the 6th of June 2015, at 14:35 until 14:45 hours in The Hague at the ICTY in the meeting room. Paragraph 1. There is no changes. Maintain the paragraph as it is in the record. Paragraph 2. The witness amends the last sentence, which in the second paragraph, which reads, I have never touched a gun in my life. The witness acknowledges that he has never touched a gun in his life for military or combat purposes, but that he owns 3 rifles for hunting and is an avid hunter. Paragraph 3. In the first sentence of the third paragraph, the witness changes dozens of tanks to 2 greenish-blue tanks. In addition, the witness clarified that he was about 20 meters away, hidden in the hills from the place in the village where the events he was watching took place. Paragraph 4. No changes in this paragraph. It must remain as it is in the record. Sincerely, Isabel Martineau and Yasmin.
Thank you. So if you were receiving this proofing note, let's say the night before, you have 8 hours before you're going to do your cross-examination, or before the testimony starts, I should say, actually. Are there any thoughts on if this would impact, or how would it impact what you're doing? Obviously, it's case-specific, but details? Yeah, this is where, again, yeah, you're going to be looking at the details. How does this affect what you've already looked at in your cross-exam? I'm not sure that this is an example where it's so egregious. Maybe that hunting, maybe the rifle thing is a serious thing. Maybe that was something you were really hoping to be discussing more as far as they'd never touched a gun. I don't know. It depends on what all the facts of the case are. That's why this is a very esoteric exercise that we're doing. But I think you would be looking at that in your questions. But I'm not sure that those were the largest changes. It just really kind of depends what that means. The greenish-bluish tanks might be a big thing. I don't know.
Could you say that, just to play like double NPR, like to go from the other side. With the thing with the rifles, could you, if you were on the other side, then use that as a way to make the witness seem like not credible?
And I think that's where you're looking, maybe you don't need to do much as far as asking for any more time or stay. Maybe what you do is you can just integrate this, if you have enough time, into your questions and say, well, and ask them about that. Well, you said this before. You said you've never touched a gun. That's pretty,
in your life.
Yeah, pretty qualitative, pretty, solid statement. And now, oh wait, I own 3 rifles. I mean, I think that's something you would definitely want to pick up as an issue. Some of those other things that came up, dozens of tanks or 2 tanks. Maybe you can get to the bottom of that. That might have been just a, the 12 to, somebody just got a number wrong. Exactly, that might have been. But it might be something where, again, were they being over dramatic in that first statement or something, and now you're trying to pin them down and figure out what is the actual story here.
And the distance thing too, because I feel like that's something that could really, if I wasn't privy to that information before and I was on the other side, I would really want to try and make it seem like maybe they really try to, get people to doubt, could they really see, how far were you, and if they're saying now there's a specific amount of meters, so maybe that could be something that would change in your questioning. Maybe you wouldn't want to attack that so hard because now there's a specific amount of distance.
Exactly, and it depends what that distance means, how far it is. I can't remember how many
20 meters.
We're in meters and yards, and I
Yeah,
never know. But that might be something where if it changes significantly, if somebody's viewing something and now it's a great distance, that's definitely where you want to figure out, what's their vantage point and what's going on. And you can work that out through cross, and that doesn't necessarily require anything more than just making sure that you're cross, and then you have enough time to prepare that cross so that you can get all of those things out, actually.
Is it mandatory to have a witness proofreading submitted to the other party, or if there's nothing major?
There's nothing mandatory. It's only even in this protocol that you have, the very last statement is if there's anything disclosable. It's pursuant to the disclosure rules of wherever you are. If you've received some evidence that's something you have to disclose, you have to go with whatever disclosure principles apply and rules and guidelines. The same goes for proofing note. If it's new evidence that they need, that would fall under disclosure. But if nothing's come up, there are witnesses where there is no proofing note. It happens. And that's what we're saying with considerations. Maybe you have nothing. Maybe you're fine and you have nothing more to disclose to the other side. All right. Thank you very much for that, ladies. And excellent drafting.
Will you be giving some notes on the...
Yeah, I'm actually thinking that I might do them generally at the end because there's some overlap. Actually, now that I think about it, because there's some that's the same in every group. So I'll just do that at the end. Maybe if we just go through presentations. Next group.
So our proofing note, we didn't write it out quite like that. We just kind of highlighted
Wasn't
points.
mandatory.
So the points that we have were in the second paragraph, why he returned with his friends to such a close distance to be able to view the events that occurred. And in paragraph 6, why he was able to identify the man when he wasn't able to identify if he was the shooter. How he was close enough or able to see that, the two.
Yeah, definitely. Did anyone else have anything, if you got a proofing note that had those 2 provisions, having watched this one, do you think there's any steps that would need to be taken as far as from the other side? I know, it's sort of in a vacuum. Maybe that's too difficult of a question to be asking. But it is really, I think, again, back down to the facts. Where are the facts of the case? And what would you do with it? Especially if you're looking at those specific, there were some long narratives of information that I think really needed to be looked at closely. If those were all being submitted, that's something that would have to be compared against the other evidence. So yeah, maybe it's all just too fact specific in witness proofing. This is all a little trial and error. Thank you very much for bearing with. You had said you'd go? Sure.
Yeah, we had just the standard information about what we're
Who was your witness?
I don't know how to pronounce his name properly. Franjo Grajic?
Franjo Grajic.
And so we just had 3 points to amend we said in paragraph 3, witness added the following statement to the end of the paragraph. No one from Verde, to my knowledge, was left in the city. Paragraph 2, witness clarified his occupation as a guard was informal and witness was not part of the VH Army. In paragraph 5, witness identified the second picture shown as quote-unquote the defendant. And then witness read the rest of this prior statement and confirmed that all of their sentences were truthful and accurate.
Thank you. Does anyone have anything with maybe getting a proving note? This is something about, now this is the defendant.
Well, I actually said that because I couldn't remember the name of him, but we didn't want to just make it up and like.
No. It's no judging on that. But I mean, if you got something that said the defendant, maybe it's okay, maybe it's not. It kind of depends on the context of it too. You know, is that an identification? If you're talking about the defendant, you know, you want a person's name in that. I'm not sure you'd get a proving note that would say that maybe when you're drafting, you would put the name, the defendant, and the name, something. You know, because that was clear, and it would be clear when it was in an exercise like this. But I think that that's something where words like that, if they're using a word like the defendant, you might have a question about that and what the context of it is.
There's 3 defendants in this case.
Yeah.
So yes.
Really,
And his statement changed, so is it like he now recognized someone, or?
I think he asked just to clarify if I knew who the picture was, because the witness statement didn't say who.
There were 8 pictures.
Right.
Where one he identified in the 4th picture.
There were 2, and then the one
she identified as.
Yeah, the defendant. Yes. Yeah. So I think that might have been. Yeah. That's why. Like, I'm not sure about that. But yes, I mean, for the purposes of this, that's totally fine. But if you're getting that in a note, you would obviously have a lot of questions about that, I think. Thank you.
Our specific case. I'm not sure, but I think that just the case that our witness is not sure about the date. With this one, we just have to cancel this witness, this testimony, because it can happen in another day or what else. It's not credible, I think.
Yeah, I was going to that. I was thinking that the fact that the witness, okay, we were the defense, so having the witness of the prosecution saying I don't want to testify anymore was very good for us. But if I put myself in the feet of a judge, the fact that the witness cannot recall 100% sure that it was on the 3rd of August and not on the 2nd or on the 4th, for me, it wouldn't make her statement completely unreliable.
Yeah. No, and I think that that's a larger issue. You had an interesting one because you had the vulnerable witness really there, and someone who was saying, I don't want to testify anymore, and it was nervous and was not going to be able to go through with this. Making comments on your reaction, oh, was what you said. Oh no, because that's a game changer. You have to figure out, you know, why doesn't this person want to? I don't think it was just the changed circumstance. It was that she didn't want to be re-traumatized. And the judge isn't going to let you just say, oh, we're not calling this person. No. First of all, you've brought them to The Hague. You've incurred cost, time. Everyone is prepared for this witness. There might not be another witness to start. You're going to have to give an explanation to drop a witness, and a very good one. Because the other side's going to want to know, too, what happened there. Exactly, why don't they want to? In this case, I think there are some good reasons, in that where you just said, she maybe not right now. It might be something where she might have to come at another time. And this is something that you would be communicating probably to the other parties, to the judge. You might have to take measures. Maybe you would be seeking, you were asking about Rule 92, or here, which would be at the ICTY, or some sort of paper statement testimony. I think that's something where then you might be looking at some of those options and figuring out exactly why she doesn't want to testify, number one, because that will then dictate if you can use any of those options under Rule 92 at the ICTY. And also, it will help you explain to the judge what's going on and what remedies might be available. Maybe we'll try to call her later. We'll see. Otherwise, you know, you can't. I mean, there's also the option of subpoena. You can subpoena a witness. You can ask, well, you can't yourself, but you can ask the chamber to subpoena a witness at the ICTY. The question will be, do they want to subpoena? I mean, what's the interest in subpoenaing somebody who's actually a vulnerable victim who's been through quite a bit, is there an interest then to be hauling her into the court and putting her through that? I mean, the court's going to take that into consideration before they would issue a subpoena, but it may be something you're asking for. It depends how valuable is the testimony to the case. How much do you need this? What was your actual assessment? Is she, I mean, I would be talking with VWU, VWS, asking them, you know, like what is their real concern? What medical concerns do we have here? You need all of that background as far as when you have a situation like that.
Yeah, but the fact that she's not sure about that, it's,
yeah.
I mean, that is basic.
Well, that's another one. That's where if you're on the other side, then I mean that's why you want to know why doesn't she want to, and now she's not sure about the date. And this is where then that's where I said that you would want to have those assessments as to whether you know, what vulnerabilities is she actually suffering from, and it's not just a reluctance because she doesn't know the date. That would be, I mean, obviously what you would hope.
Yeah.
Because if it's just the date, that's going to be a problem. She's probably going to be called, if not by you, by the chamber.
Yeah.
Or you will face that subpoena probably if there's not a valid reason.
Maybe.
Sorry, you had a.
Yeah, maybe
question?
it could be a contempt.
It could be.
For instance, or someone being put under pressure, or providing someone some measures, protective measures to keep that person probably there.
Yeah.
And you can file an urgent request for.
Absolutely, and that's where you just need that whole full assessment of what's actually going on
Yeah.
with this woman.
It's my own opinion. All testimony is real, but I knew, I heard, it's not, I know for sure because of this and this.
Sometimes, yeah, sometimes you're stuck with that, though. You know, you're going to have, it might not be the best witness you have.
Yeah, how credible can be.
Yeah.
Like, how do you recognize that belonged to this army? Yeah, I knew for Danko, yeah.
And that,
you
yeah.
knew, but
And that's something that should have been done in those initial interviews as far as assessing whether this is a witness who should be called or
Yeah.
not, a long, long time ago. But you're now the person in that situation and dealing with it. And like, as I said, it might not be the best witness. And if they do go on the stand, maybe they are, you know, not very qualitative, maybe they're just wishy-washy, maybe they don't necessarily know. But, you know, there are witnesses like that. Not everybody is solid on everything. There's faded memory. So, sorry, you've had your hand up.
Yeah, but what happens if it turns out that this victim now is psychologically traumatized and that she will simply not be able to testify in front of the court, but that we have another witness that fled from the village the same day and that saw that her and her sister stayed behind.
Yeah.
Would that be a corroboration of the date?
Yeah, and it depends. I can't remember in the file. Is this already in evidence, or is this another witness that's in the file?
No, that's just
Just another person. Yeah. If you can find that person, of course, definitely you could probably ask that one. If you find that person, they're willing to testify. You could ask to have that person testify in this person's place, and here's why. But you're still going to have to give reasons as to why she's not testifying anymore. And also why you didn't talk to this person in the first place. You should have done that. This person should have been spoken to a long time ago. The minute you took that statement and you knew that there was another witness out there, that would have been a minimum of due diligence to seek out that other victim witness to see if they had a story. And maybe they did, and maybe we just don't have the statement here. Maybe it's a part of the file somewhere. I mean, it would be possible. There have been times, it depends on the stage of the case, too, as far as if you switch one witness for another witness. If this is happening in the pretrial, again, why it's good to do it early. If you're doing this at the pretrial stage, you haven't maybe submitted a final witness list. Maybe you can then, and maybe this is still just sort of an assessment, and that's okay. But if it's, the eve before trial, you're going to really have some problems in not calling a witness. You have to have a very solid reason. Vulnerability, psychological implications, very good reason. Yeah, I think you're going to have some footing there to get that, but. Yeah.
Then just going back to this date thing, because I'm really curious if, although it's clear that the victim is psychologically traumatized and that she will not testify, at least in the coming month, would the fact that she's not 100% sure of the date disqualify her?
No.
So it wouldn't mean that her statement would not be reliable anymore, right?
Well, the thing about evidence is that it'll come in as far as she might say, I don't know if it was the second or the third, the fourth, I have no idea. In fact, I don't know what year it is. I don't know what planet I'm on. That might be her testimony. It really might be. But then that's where then the judges later have to assess this. And when you're making closing arguments, you'll say, this witness is not reliable. She simply cannot figure this out. And it's not that she's trying to be evasive. She simply doesn't know, and she might have some lingering effects. There might be psychological reports in evidence because of what has transpired. And you might be saying, this person simply isn't a credible witness, and therefore you can't rely on her to convict the client, or you can't rely on her for whatever reason, if you're on the prosecution side, to acquit the client over here. Whatever it is, you're going to be making those assertions in your closing arguments after a full scope of it. But her witness testimony might be that sort of all over. You don't know. A lot of witnesses don't know the date. Nobody remembers. I don't remember what happened 10 years ago. It was like, I think it was this day or that day. I'm not sure. Dates especially are very difficult. Unless something very, very horrible happened. Then sometimes that's a reason where a witness says, I know it was that date because I will never forget that date in my life. That goes to credibility, I think. But they might not know. They might say Saturday, Sunday, I'm not really sure. In which case, then you'll be looking at other evidence, and the judges might say, look, if you'll read in judgments, they weren't sure about the date, but they were sure about all these other things. Yeah. And that's okay, because it matches up with this witness and this witness. Therefore, we find it's this date, and the judges will find that. It doesn't have to be, I know it's this date.
So a contradiction between different dates is not a substantial role to challenge testimony or...
It can be. It depends on what else is going on.
Okay.
You know, if there's a lot of other changes, a lot of things
use
that don't.
that, for example, in the future as a ground to diminish.
If I thought the witness was not credible and they couldn't be sure about the date, and if the date was really something they should have known, you might be making that argument. You might not. It depends what your goal is and what the larger picture of evidence is.
Okay.
I mean, if it matches up detail for detail with somebody else who does know the exact date because they had a watch with a date and they were looking at it the whole time. I mean, okay, that might be something. But then if there are too many details that are close, maybe you're challenging that the details are too close and they sound exactly the same. I mean, you have to look at all of it and see what it is that you're looking at. But no, not knowing a specific date definitely isn't going to keep anything out. That's just the way it is sometimes. People don't always remember.
Well,
we're all
we had
human.
one of the cases, I don't know if I would want to mention, but where someone gave a full testimony, direct testimony about the accused, and then the witness described the accused as a completely different person, like tall, big, chubby, which was completely so that the witness was, I think. At a certain point, the judge interfered and asked, can you define the accused in the chamber? And it was disrupted by the defense, I think. It was a big issue.
Yeah, I mean, it depends. Like, for identification especially, it can have all sorts of things that go on, and you can use it whichever way you want. Maybe, I mean, whatever way, maybe if they're describing somebody who's totally different and is going a different way, and you're the prosecutor, maybe now you've said, well, they weren't sure about other things, but that doesn't discredit this part of their testimony. The judgments are rife with analysis of a witness, a fact witness especially, where they say, look, they're not credible on this issue, but they're credible about this. A witness isn't always totally incredible or totally credible. A lot of times they're credible about this, but not credible about this, simply because their recollection was better in this instance, or they had better information to know this. So it's not black and white sort of a thing. Again, we're back into gray as far as what it is that the witness can actually testify about in a reliable manner. And then that comes out on appeal all the time as far as these issues. So,
yeah, which is what I read all day.
Thank you very much. And, oh yes.
I have a question. For instance, with the girls, we arranged to sort of give me the testimony and make corrections about it myself. But I saw that in other teams, the counselors would ask questions about almost all parts of the testimony. What do you think is the best practice, or they're both correct, or?
Well, I think everything's correct. It depends on what you're dealing with too. I mean, a lot of them, and you have to look at different jurisdictions. Some of them say, you know, they're going to get their statements from the registry already in advance to read. And actually, when you come in to proof the witness, they've already read them, and that's already been done, and that's not your responsibility. Some of them, so then you may want to sit down and say, you know, is everything correct? And they say no, and let them guide it, and let them lead. Sometimes you may, if it's somebody who's all over the place, maybe you want to keep it controlled and say, let's start paragraph 1, let's start here, and let's go paragraph by paragraph. You do sometimes in that method, then sometimes you'll get people, oh wait, no, but I want to go back. Okay, yeah, it's an imperfect science. You're going to have that, where people will remember things from here that then they'll go back here. That might happen. But I don't think there's any one right way. I think it really depends on who you're dealing with. It might not even be, this is the way we do it for everyone, because the certain witness might need to be led through it specifically. Or maybe they're an organized person. Maybe they made a note themselves. I've made all these corrections here. In which case, they've sort of guided it, and they've took control of the situation. It really depends on who you're dealing with and what their background is. Is it somebody who is a general in the Army, and they're used to, they get this and they make all the corrections on the side because they know, and there's like time notations by every correction they made. There's something very rigid about the process. Is it this woman who, when she looked at it, and she doesn't know, she's all over, and maybe she needs to go paragraph by paragraph because she's a vulnerable witness. Based on what she's been through and pre-assessments. So it really depends on the person, I think, that you're dealing with and the context of everything.
And the time you have.
Amount of time, yeah. If you don't have a lot of time, you may want to say, is there anything you want to change about? Yeah, you have so many factors, yeah, definitely, that you have to take into consideration. But yeah, I don't think there's any one right way. As long as you're, you know, within the bounds of everything that's ethical and wonderful, then I think you're okay. And efficient. Efficiency is always good. Somebody?
How much time do you normally have to witness proof?
Not a lot. It depends. I mean, it depends. Really, for each witness, it's going to be different because usually, and correct me if I'm wrong, since you're in, you're in the middle of it. Yeah. Typically, the witness will come in. You have a witness who comes in. They're picked up at the airport by the victim section. They'll bring them in. They get them into their hotel room. They tell them blah, 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 blah. Here's your basics. Here's what you need to know. And correct me if I'm wrong. Here's what you need to know about everything. And there's probably an appointment already made with the defense team to proof the witness right away. Because this witness is probably going to be testifying, if not tomorrow. Usually there's a day in between or so. Give them some time to acclimate. The next day or the next day. Sometimes there's a delay and they end up staying longer. But in total, they're only going to be there about 2 days, 3 days, ideally for the court's purposes, 3 days at most beforehand, and afterwards they'll leave right away. They don't, like I said, they don't want a bunch of witnesses here, you know, just hanging out, and it's hard to manage. It's more work for the victim section, for the registry sections. It becomes cumbersome. So they're trying to get people in and out, but on a regular basis, rotating. But it's also difficult when, as far as sometimes some witness can go long in trial, or some might be shorter. One time, one of my counsels stood up and said, I have no questions. We thought he had 2 days or something like that. So then you're like, ooh, where's the next witness? You know, you have to find the next witness quickly and bring them in. Now maybe you didn't have a lot of time because maybe they're in the middle of proofing with the other one and you thought this attorney was going to ask questions, but something happened in the direct and now there's not 3 days of questions. There are no questions. It just happens, and so you have this ebb and flow where then you might not have any time. You thought you had 2 days or a day, you have no time. Okay, so usually you're trying to be as prepared as possible, but things do come up once in a while.
It does happen. I had one instance where the plane bringing the witness was delayed. It came late at night. Pursuant to VWS's instructions, we're not supposed to have proofing for a certain number of hours after they've arrived to let them kind of adjust to everything. So we had just sort of a brief meeting introducing ourselves to the witness, and the next morning we started proofing, and approximately 1.2 hours into the proofing, we got the phone call saying, where's the witness? We might need him to go to the courtroom. And so thankfully that was not the extent of the proofing. We were able to get the court to adjourn the proceedings based upon the late arrival of the witness. But essentially, sometimes you can only get an hour with a witness.
And the court will be flexible, I mean, where they can be flexible, but sometimes it's a matter of the schedule. I mean, it's such a nightmare. People in the room can attest to the fact that it is it's a jigsaw puzzle trying to make sure that you get witnesses here when you need them here, to make sure that everything moves as smoothly as you see in trial and there are no gaps, breaks in sitting. To keep that is really, it's an amazing job that people have to work at to make sure that the timing is just right and all of these things. It's actually quite incredible, but you have to then have that flexibility that sometimes you might have a day, you might have 2 days, you might have gotten an extra day, you know, oh, okay. But you have to just try to plan accordingly and do what you can do. And that, again, yes, that will also shape timing. How much time do you have? So, the group in the back, I don't think had any observations. You had a lot going on in yours.
Yes, well, we think that if we will be the defense team, we will try to invalidate this testimony, arguing that as we are in trial stir, and the threshold is beyond reasonable doubt, we cannot use this kind of evidence in order to justify that. And if we will be the prosecution, we will say the contrary, that hearsay is not inadmissible per se, so we can argue that. We can use that as a testimony. And the picture, I think that is not something really useful, because as
I don't know. This one's not useful? But you left. This is all actual evidence in the case. So maybe it's useful. Maybe it might be. It depends again on the context of the case and what's actually going on. I agree with you. This one might be more relevant based on who's there and what's going on in this. That one.
And what about the one I didn't want you to see?
That one might be something that's more relevant as well. It kind of depends. Again, facts. You don't know as far as facts, the case doesn't have anything to do with it. But they can be relevant. They can, here, out of context, but they're evidence because they were relevant to a specific purpose to the case. And so it could be. So what that means is, as far as disclosure then, are you disclosing these to the other side? That's the question in the proofing session. How many people, raise your hand, would you disclose these to the other side? All of them? This one?
No, there must be some kind of selection. Maybe.
It depends. It depends if you're the prosecution or the defense, and you have to know the rules as far as you have to. If you're the prosecutor, I mean, you have to look at these things. I mean, maybe this one has nothing to do with okay, let's go with this one. What does this picture tell us? I mean, maybe you have to look at the case. I don't know, but out of abundance of caution, because there's nothing going on here that I see other than hair and acid wash denim. Other than that, I think that I would disclose it out of an abundance of caution, just to make sure anyway. I mean, that's usually the position taken. We're just going to disclose this anyway because you don't want to be in trouble in violation of not disclosing that, and that doesn't affect the case.
Okay,
if
so
you're the prosecutor, that's a different side from the defense. The defense doesn't have the same disclosure obligations, but if it is something that you're going to be using in the case, if it's relevant, then you have to make sure the other side is seeing this. Otherwise, you might be barred from using it when you're actually in the courtroom.
And remember, I did say for one of the photos that it was in verde, so that one definitely would have to be disclosed. And you may want to ask if I have any other photographs from verde, because that might be of relevance to the actual indictment.
Or, for example, the order that he left at home.
Can somebody obligate him to bring the order, or because I think that this is very important.
It depends who's questioning here. Honestly, I think either way it has to go in the proofing note. What was said has to go in the proofing note. As far as how active you are in getting the order, I think most people would be interested in seeing what's in this order. And that's where you're going to put it in there. If you're the one who was saying there was an order to do this and that, absolutely. If you have the resources in the field, you're calling somebody up to see if they can go and get this document. If you don't have the resources, this is difficult. You might actually then be asking for, in proofing, he said he has this order. This is going to be very critical. In fact, I might have questioned a little bit more on what's in this order. As far as, Your Honors, we need to maybe take a pause. We need to get this document. We can't get it until tomorrow or the next day, and we need to see this before we go forward to make sure that his testimony is the most effective it can be. It might warrant that. It depends. I mean, an order on that day in verde from the forces, I mean, and from the guy who wants the protective measures, this might be critical or very, very integral to the case, and it might be something that you might need to take a one-day pause to try to get that document if you can't get it, and disclose it to the other side. Sorry, there was behind you. Yeah.
As well, the two statements was done, but the same investigators.
Mm-hmm.
So as well, they were signed by the same persons. It's a big problem. So between 1996 and 1999.
That the same investigator investigated?
Yes.
Yeah, I mean, that might be something that's, that's something that's brought up as far as when you're dealing with it on cross, especially, something you might be looking at, and I think that would go to the line of questioning. Because I think that with these two statements, that's a disclosure thing where both sides will have these statements, or should have these statements. If they don't, that's a different problem. But the fact that they have these, they'll be able to look at that as far as when they're doing their direct and cross-examination. That's not a point that's going to come up, especially since this one is already a clarification, and now he's making more clarifications on the clarifications. You might have a lot of questions that you might be touching his credibility if you are the opposite side. If you're the side that that's presenting him, you might be really trying to protect this and try to somehow find a way to explain.
This document, we don't have the date of the statement of the comment Artukovic. So maybe the second statement signed maybe after the first statement of Artukovic.
Yeah. Well, I think also that's important that you raise that. Thank you, because multiple statements are usually where you're really going to get a proofing note, because they have to somehow come up with which one is
maybe
which one's right.
The prosecutor and the defense.
Well, and it's something where whoever's calling them and proofing them is going to be questioning those and say, what's going on with this one? What's going on with this one? What's the actual story? We need a clarification on that. If they aren't.
We said the testimony of the accused with the testimony of the comment.
Oh, you mean with the rest of the record?
Yes.
Well, yeah, the rest of the record, I mean, for those, that's where you're going to be saving those things for your final arguments. You're going to weave it all together into a story and tell them, this is why this isn't working or is working, and this is what's happened in the life of the case, because you have that whole record in front of you. Absolutely. There's a lot of gaps in this record that could be.
But one thing for proofing, irrespective of which side you are, and in terms of the information you have to give to the other side, when the witness changed to say he no longer saw the killing and he was off somewhere else with Captain Boban, that is an alibi for Captain Boban, who, according to the other witnesses, was the one that shot the people in the center. So that would definitely be something that would have to be disclosed to the other side. If you represent Captain Boban and you want to use that, you definitely want to get that out there and confirm that he said it so they can't go back and change his mind later. So I think that's a fact that both sides would have to disclose in their proofing note.
Yeah, I definitely. For this, we're doing this, like I said, in a vacuum, a very hot vacuum, where you don't necessarily have all of the disclosure. What disclosure rules are we under right now? And that's where you would really have to use those. And it says that in that protocol, the disclosure rules apply. And whatever you're learning here is going to be subject to those. So you have to look at exactly what disclosure rules apply and abide by those to be compliant with whatever process they've set up in this protocol here. And in generally, even if there's no protocol, you have disclosure rules, and they are extensive, and a whole training, probably. Actually, disclosure would definitely be a training. And something where you have to know those in and out and know, on both sides, know what you need disclosed to you, know what you need to disclose. Both sides. Full stop. There were a couple other Easter eggs in the, sorry for that, it was my fault if it wasn't clear as far as that we had some very skilled witnesses. Thank you for that. We had a couple of, they had some ideas planted as far as what they might be bringing to The Hague when they came. Some of the others that did not come out that we were discussing, what do you want me to say? That witness, just tell me, what should I say? We can't tell you what to say. This is about the truth, and that's where the instruction comes into play, and the guidelines and the understanding. But you might have that witness who just is not understanding the process and asking you, but what should I say? What has been said? There were a couple of them that asked, what did this person say? I want to know. That might help me clarify. it's not possible. That actually was handled really well maybe over here, but it was, now is not the time. Maybe at another point you can see what their testimony was. Now is not the time, and that was very good to explain that it's not forever. You'll find out one day, but for the purposes right now, you can't know, sorry. That I think was really good on that. Sometimes you'll get the, well, no one ever asked before, but, and then a bunch of information. This is, again, your job to decide if this is relevant to the case. This might be, again, this is Aunt Edna's recipe for cake that she made every year until the war started, and then she stopped making cake. But the recipe is as follows. You have to really control what's going on, too. Sometimes people just like to talk, and you're listening, and they're finally telling their story, and there's so much more than just what happened on the 3rd of August. It's such a large story of their life, and so they might want to tell you more, and that's where controlling it, I think there was some groups did a really good job of controlling what's going on. There were some long swaths here and trying to get that together, but often it'll come in the context of no one ever asked me this, but, however, no one ever asked me this, but could be a gem of evidence because somebody didn't ask the right questions in the field. They didn't even think. It was ages ago. It was a different case. Nobody ever asked me, but I have the order from the 3rd of August. Do you want that? Yes! That's something where, wow, okay. So it could be good or it could be, wild goose chase. You might be over here. I don't know. You have to really know your case to know where those limits are. Other incidents, that's the same sort of a thing. We had some other incidents crop up. Again, you're filtering here as far as keeping it focused. Direct implication of somebody. There was one that came up where all of a sudden, the defendant. I see the defendant actually in this photo board now. That's pretty significant. Or if somebody gets named now or is now identified, that actually was one that we had hidden somewhere around too. And just sort of had that on your own. So that was happy accident.
Yeah. So about the identifying people at the time. I mean, if there has been so much time, they could have seen photos of them anywhere. So
yes.
Doesn't that just make looking at photos again completely irrelevant?
Well, yeah.
There's the internet. I mean, you can look up everything and just Google images anyway.
I appreciate that you're saying that. There might be a case or two. No, where you're discussing in-court identification. I mean, it's him. Well, of course it's him. You looked online and you saw his photo. Yeah. I mean, that's why most of these chambers do not allow in-court identification. It simply does not make sense. A lot of the cases aren't even direct commission. I mean, some are, but there's a lot of JCE, so it doesn't matter what that person looks like because they were a part of a joint criminal enterprise or a co-perpetration to commit these crimes. And so it doesn't matter if they were on the ground or anywhere. You didn't have to ever see them. But if it is direct commission, yeah, and that's something, again, this is where you're getting into your final arguments as far as even if they identify them. There's also the difference between identification and recognition evidence, which is extensive, again, another day of training as far as that goes. Sure. And photo boards, because this includes photo boards probably for the purposes, because this is used for the mock trial, that photo boards are a huge issue where you have a lot of guidelines, certain ways you have to do things, a lot of issues that come with that. And again, back to the identification and recognition, I'm sure that's all worked in there as far as the larger picture, and for our purposes, it's just sort of a little extra there. Okay, so just a couple quick notes on these. The first one, you didn't have a second interviewer, which the protocol requires a second interviewer, though exceptional circumstances could have been made. So I think in a proofing note, I would, if there's only one interviewer, just because that's in there, give the reasons why this is an exceptional circumstance. The co-counsel is in the hospital and we have no one else on our team because they've all gone to Bali on a yoga trip. And maybe there's all of these things where just something was exceptional, but I would include that if that requirement's there, put that in there to preempt, this is why this happened that way. Yeah, definitely asking for clarifications. I think that's very good. A lot of you went through the rules really, really well. Those first 4 things that you have to tell them, but telling the truth. Make sure if those musts are in there, and like in the protocol, you get those 4 things out, and make sure you do those at a bare minimum. And that would be something you'd put in your proofing note. I think I would anyway, as far as they were given this, they were told to tell the truth, they were told blah, 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 in accordance with blah, 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 to make sure that that's all in there too, so no one questions if you skip this and then they're asking for the video and then you have to disclose the video, and it wasn't necessary because you simply could have written, these parameters were defined for the witness. The witness said that he, she understood. I would actually even make sure you get an affirmative that they understand these things and put that in there as well, so it's very clear that that was done, since it is a mandatory requirement. If there is no protocol, well, then you don't have to put that in there. Then it's just a free-for-all, but since we were working in that, I would do that. Somebody was talking about how the judge will intervene. I think over here, a judge will intervene if there's a problem with the questioning and explaining some of the practicality. A couple teams did a really good job on that as far as talking about the practical elements of it and explaining that 5-second rule. And it was a really good job as far as how that is unnatural and how it's going to be a little strange, but this is the way that we have to do this. And setting people's mind at ease. Again, I'm on the same page here. So, what about lunch? Well, as long, these are human beings. You have to treat people like people, and make sure that, again, this goes to their setting them at ease. There'll be lunch. It might not be fantastic. It'll be a sandwich, but it'll be tasty enough, and we'll sort you out for dinner. As far as the victims and witnesses unit can tell you how that will happen, and it's. All of these things, setting them at ease, as far as just basic concerns, I think is really good to make sure. And actually, the paragraphs by paragraphs, I think it can be a very good system if you want to keep solid control of something as far as going point by point, and you have the time. What you saw and not what they saw. I think that was a good line as well, as far as when people are talking about, they want to know what other people said, because that is something where, people might want to say, well, what did so-and-so say about this? Well, that's not something that we can discuss right now. It's about what you saw, not what they saw. We're focused on your experience. I think, let's see, number 22, one team did the provision about the investigators. You can't be asked about anything, it's over here, that the investigators have already asked about. And I think that was a pretty good way of explaining it too, but don't worry, then again, don't worry. The people there know what can be asked and what can't be asked, and we'll take care of that, and we'll be there. I think somebody said, we'll be there, don't worry about this. The instruction about referring to the judges as Your Honor or Mr. President. That was done by one group, and I think that's good, because who would know? I wouldn't necessarily know how to address the judges, and it was followed by the "Don't worry, we've got this." You shouldn't even need to address the judges, but to just understand that, I think that's something that probably will come through in the familiarization process, as far as telling them, who everyone is and how to address everyone. But just in case, I don't think it hurts, because it is adding, it's your witness. And that's adding a level of respect that is going to be necessary in the courtroom, that I think then, if it does come up, they are then prepared in a proper manner. And back to those U.S. standards, as I was saying, as far as making sure that you prepare them so that they know what they're doing there. They should be referring to the judge in this manner. I have the protective measures. If somebody's asking for protective measures, it's something where you might want to simply say, we'll sort that out, we need to figure this out. That's a totally different, that's its own process, as far as that probably should have been done long before. But that's not to say that they're not showing up and saying, actually, I want protective measures, because that happens. And in that case, then you say, okay, we'll look into that. Right now, we're going to talk about this, and actually it's a separate process of why do you need protective measures? What do you need from the protective measures? What concrete actions have been taken? And you have a whole process that you'll be engaging in there, as far as if they're asking that. But when they're telling you that their testimony is contingent upon protective measures, that might be something, you didn't have time here today at all because it was so short and set in a vacuum. But that's something where you might want to take care of that right away and make sure that you're getting these protective measures, or at least you can't just get them, but that you're taking actions to try to get protective measures for them, and assuring them that you're doing your best to do that, so that you can proceed with the rest of it. And then, having somebody else filing that motion while you're proving. How many were in the group, found the order at home, brought the photos, he's a saint, all of these things. When you have this witness, he was maybe all over the place as far as a little unleashed. This might be a paragraph by paragraph situation, because he's bringing in a lot of new elements. And some of them might be really interesting. That order might be really interesting, and you need to be just on your game to mark all this stuff down and really address everything that's coming at you, because there was a lot going on there. But that can definitely happen. People think, oh, I'm going to go testify, and that was about this. I think I have that file somewhere, which maybe they didn't have it before, maybe they just forgot about it. Oh, that's right, I meant to take that. You know, because they're being helpful and they're bringing the documents, and that's great. But that, for you, that is something where you have to treat that very seriously, because that's disclosure that you didn't have before, and now you have to deal with that and figure out what it means to the case. Maybe it means nothing, but maybe it means everything, so you have to really look at it. I think everyone did a really good job of abiding by the protocol, I'll say. Really, like I said, to go through those steps and make sure that you were not, everyone was very careful not to be influencing, suggesting, as we saw earlier. I think that is very, very, that's the biggest worry about all of this, and that's the reason that they have to have the parameters and the reasons for the recording. And the reasons that people want to prohibit it is because of that. So that's what I think your main concern is, that you're not influencing the testimony. That's the primary concern. I mean, as far as telling them, if you forget to tell them that, you know, the judges are called Mr. President or Your Honor, that's okay. That one might be okay, but as far as influencing testimony, that is not okay. And I think that's the takeaway from here. It's a hard thing to define as far as where the coaching line is, if you're allowed to go this direction. But you have to really know what it is, especially to yourself, so you can explain any situation, any action that you took. So.
Like, what if you tell the witness to, like, already answer 5 seconds later, just so he gets used to that? Would that be coaching?
I don't think so. I think that might be. I don't think so. I think it's just a practical. I mean, you're not influencing what they say.
Yeah.
You have to think about, you know, you're telling them, again, it's the how they say it, not what they say. So if you're not telling them what to say, I think it's probably okay. I think that might actually be an interesting exercise. I'm not sure you have time to do that in your proofing session, but if you can, it is, because it is such a difficult process. And things, if you know, from watching court, you'll see things get out of hand really fast when people are speaking over each other, and then the interpreter is telling them to stop, and then everyone is frustrated, and it makes a really tense dynamic that you want to avoid. So it is an important rule if people can remember, and the judges will remind them, the interpreters will remind them, but it's good if they know that that's coming. So yeah, practicing, why not? Cross-examination notice of documents. Oh, right. Beforehand, I wanted to also, at the break, you have to consider too, as far as if you are required to give notice of your cross-examination documents. This happened in a case I worked on where we had to give 24 hours notice of the documents we would be using in cross-examination. Well, if you don't have proofing, okay. But if you have proofing, this was absolutely, it became to us where you'd have absolutely no spontaneity, because you would be giving the cross-examination documents that you were going to try to challenge the evidence. And then in the proofing, which was being done within the 24 hours, now maybe the 24 hours helps if you can match up those deadlines. And then the prosecutor in this case was then, of course, taking those documents and then preparing the witness with them and saying, oh, here's this one, what do you think of this, here's this. So then there was no element of trying to get them to understand, to test their credibility based on the documents you had, because they were done in advance, but there was no bar on the proofing as far as 24 hours. If you have the protocol that says, okay, this has to be done 24 hours in advance, and then 24 hours notice of cross-examination documents, that might make sense, because that's all right, then there's a bar, they can't actually show those. But keep that in mind, that sometimes there is a requirement to disclose what you're going to use in cross-examination, at least to the ability that you know you will, because, of course, cross is supposed to come from whatever happens in direct, so it is hard, it's an anticipatory exercise. So there are things that do come up, and they will usually allow it, but this is something you have to be aware of as well, how that works with proofing if you have to give advance notice of cross-examination documents.
Why would they require that?
For preparation of the test, basically for order of the court. It was there's 2 or 3 cases that did that at the ICTY. It's not that common, but it did occur. It was for the ease of proceeding, so everyone knew there was not. It was more for the parties and for the judges, so that they were prepared as to what was coming and they could look at it in advance, I think. But this is the outcome, is that the witnesses had it in advance too, where you might not necessarily have that. As far as things like if you're going to be asking them questions and you had, let's say, a camouflage chart and you wanted to ask them about what camouflage, they said, well, then now they're looking at it in advance and they've already had time to study and look at it. Whereas it's not the spontaneity of, I think it was this one, I'm not sure. I mean, and to whatever degree that's even useful evidence, you know, that's for the judges. But it does factor in, if they've already looked at it, well, then there's absolutely no point in doing it, really. questions? No? Are you all napping secretly with your eyes open now because it's warm? I think it's, what time is it, 4:15? If no one has any questions, I think we can probably just call this one a day. We've digested a lot, and it's very hot, and it's summertime in The Hague. And I'm free, if you have any questions, I'm free to answer any, and you can all have my email if you need to ask anything in the future. I'm really happy you came. I know it's really warm in here, and have you stayed? Actually, I was worried about lunch. Because this is a really interesting, so like I said, it's trial and error. This is not a training I've seen a lot of, but I think it's really useful. I think it's really good to know those limits. And so I'm very happy that you're all willing to participate in trying out these exercises and going with it. So thank you very much for that. And thank you to these lovely ladies who helped. And again, to everyone who very, very useful. So thank you, ladies. Thanks to Isabel, who's not here, who is in Bali.
She is in Bali.
Thanks.